time, the Chief Justice is joining us. And we shall have anthems first, followed with an opening prayer, and then we shall continue with the program. So my PAs, please prepare for those anthems. us all rise and receive the Honorable the Chief Justice. My Lord, you are most welcome. We shall start with the anthems. As we remain standing, may I request Honorable Justice Alan Nshimye, President Judge Mbara, to come and give us a prayer.
Let's humble ourselves as we commit this 7th annual National Conference on Plea Bargain into God's hands. Dear God, we thank you for this day. We thank you for the Chief Justice. We thank you for the Deputy Chief Justice. We thank you for the Principal Judge. We thank you for the judges and justices. And we thank you for their worships present. We also thank you for the DPP and the team that prosecute matters in the name of the state. We also thank you for the private lawyers and Uganda Lawyers Society that represents the accused persons. We thank you for the jealous sector players that are here present today. We also thank you for Professor Gash, Professor DeWalt, and the team from Pepperdine University. We thank you for the partnership between the Judiciary of Uganda and Pepperdine University that has lasted this long. And we pray, Lord, that you guide us today to have a fruitful conference. In your mighty name I've prayed. Amen.
We may take our seats. My Lord, the Honorable the Chief Justice, my Lord, the Deputy Chief Justice, my Lord, the Honorable the Principal Judge, the Justices of the Supreme Court, the Court of Appeal, and the Judges of the High Court, Your Worships, invited guests. Specifically, the magistrates in the pilot public defender program on plea bargaining in the magistrates courts, they are all here. We have members from the Uganda Prison Service. We have members from the police. We have registrars and chief magistrates and magistrates present. We also have other ADR experts amongst us who have come to join this conference. My Lord, we equally have from the Pepperdine University, we have His Excellency Professor Jim Gash, the President and Chief Executive, Pepperdine University, who will be at an opportunity.
All our distinguished friends from Pepperdine University present, your worships, members of the Fourth Estate, invited guests, ladies and gentlemen. Good morning to you all. I take this opportunity to we are greatly honored to host all of you here today. Thank you all for taking time off your busy schedules to attend this function. Plea bargaining is not alien in the Ugandan cultures. It has has roots in the Ugandan traditional values that promote reconciliation and asking for forgiveness. It is not surprising that the framers of the 1995 Constitution of the Republic of Uganda had this at the back of their mind while drafting the Constitution, which in Article 136(2)(d) thereof requires courts to promote reconciliation between parties in the course of adjudication. Therefore, the judiciary, in the year 2014, with the support of our great friends of Pepperdine University, developed and started implementing plea bargaining as a case backlog reduction intervention and strategy. The performance of plea bargaining is exceptional in terms of case backlog and case load reduction, as well as minimizing costs in the administration of criminal justice. But it is also advantageous to the accused, because the accused has an opportunity to participate in his own sentence, which is not the case when a conviction is handed over to the accused. When a conviction is handed over, the accused only has an opportunity in a rochetas, which is almost like a standard format, which they always say, I have so many children, my father is ill, I'm the one taking care of them, etc., etc. By way of an example, I've reviewed performance of plea bargaining statistics, and interestingly, Mbarara High Court Circuit comes at the top. From January 2022 to June 19, 2024, Mbarara High Court Circuit completed 1,320 cases through plea bargaining. Of that number, 518 were non-capital cases, whereas 802 were capital cases. In the same period, Mbarara High Court Circuit completed 364 cases through 9 criminal trial sessions. 40 cases are cause-listed in each criminal session. Now, in this, I want to brag a little bit. The first time we had the highest number of cases completed in any plea bargaining session, I was the resident judge in Mbarara, and the Honorable the DPP was the focal person. And Justice Kavuma was also a judge of Mbarara. So we completed then 200, and if I recall the statistics were 212, I think. And it had never happened in this country. So I thank the Honorable, the DPP now, because I remember she actually one time, together with the Joyce, they were in court up to 9 at night, trying to ensure that those who had signed agreements do not change their mind. So they were trying to convict them. And so the OC of prisons came to me and said, "My Lord, we are in trouble, because if any prisoner escapes at 9 at night, I will be arrested." So I had to say, "My Lord, let's stop here. Whoever changes his mind, let him change his mind or her mind." So thank you so much, because that set a pace that we are now witnessing, because Mbarara has never gone back. So what does that mean? It means that the judges in the circuits must take plea bargaining as a critical tool for case disposal. And how do you do it? You must sensitize regularly. I used to go to prison with Joyce almost every other day. And the prisoners eventually get convinced when you tell them the advantages. Comparatively, if I gave you the statistics, if we maybe I forgot that actually in that plea bargaining session, it was Pepperdine that played a very big role, because they brought students. So I committed the crime by forgetting you, because it's you that were the counsel the other side that helped us to finish all of those numbers. Thank you so much. So now I gave you the statistics, but let's do comparatively. So let's do a comparative analysis. Comparatively, if we convert into sessions
the 802 cases completed through pre-bargaining by the circuit, we would need 20 criminal sessions to dispose of the same number of cases. This translates into 7 criminal sessions for a circuit each year. With our meager resources, we cannot afford such number of sessions. So if you notice, 20 criminal sessions, and the amount of money, of course I have not gone into the amount of money. It would be amazing. In addition, a negligible percentage of cases completed through pre-bargaining go on appeal. It is the session trial that account for vast number of appeals in the appellate courts. Therefore, that means that quite often, full trials process a lot of workload for appellate courts, whereas pre-bargaining often leads to less work in the appellate courts, hence helping in case load and case backlog reduction at a cheaper cost. But remember that also a trial is also lengthy and sometimes nerve-wracking with all the data evidence sometimes that come in and sometimes cause mental stress to the judge. Allow me to take this opportunity to commend Mbarara High Court Circuit for exceptional performance exhibited in implementing pre-bargaining. As I earlier stated, if they completed 802 cases in pre-bargaining and only 364 cases in criminal session trials, it means pre-bargaining is more than 60% of their trials. This is highly commendable. Imagine what we would achieve if this level of pre-bargaining success can go to all courts. I encourage all our judicial officers to interest themselves on what Mbarara High Court Circuit is doing better and implement good practices from Mbarara at their respective stations. My hope is that if every judge can complete 100 pre-bargaining cases each year, in addition to normal station duties, that would be a significant game changer in ensuring timely administration of criminal justice at minimal costs and reducing both caseload and backlog in all the hierarchy of courts. As I conclude, this is a one-day conference, and as you may have read from the program, there will be award of certificates. Please attend and learn as more as you can. Learning is a continuous process. Learning never stops. It only stops when you die. Allow me to take this opportunity to thank Pepperdine University for maintaining collaboration and support the Ugandan judiciary. We cherish your friendship and support. Thank you so much for listening to me, for God and my country.
Thank you, my Lord, for those welcome remarks. My Lord, the Honorable Chief Justice, we are moving into session 1, where, my Lord, you will be chairing the session. And this session, my Lord, will be covering the relationship between Pepperdine University and the Judiciary of Uganda. And later, we shall have a pre-bargain quiz. And our distinguished presenters are present with us, my Lord. And with your permission, my Lord, I pass on the chairmanship. Thank you very much, my Lord.
Thank you. My Lord, DCJ and members, for this session, we have 2 presenters, we have 2 resource persons. First will be Professor Danny DeWalt, who really needs no introduction. He's a household name, being a true member of the Ugandan judiciary family. Is Vice President and Chief of Staff of Pepperdine University. Pepperdine University is not a military outfit, so do not be misled by the title Chief of Staff. I would like to think the Chief of Staff is the person who spins things for the institution. He'll be addressing us on the relationship between Pepperdine University and the judiciary of Uganda. He's been a key player in this regard, and I will not take away from him what he'll tell us as being a member of our judiciary family. Professor Danny DeWalt.
My Lord, the Honorable Chief Justice, my Lord, the Honorable Deputy Chief Justice, my Lord, the Honorable Principal Judge, with your permission, I will adopt the protocols previously observed and move forward with my presentation. Good morning. It's great to be back. We got back early yesterday to our home country. We now call Uganda our home country, and we visit the United States from time to time. You've made us feel like family, brothers and sisters. We see so many familiar faces among you and some new ones that we long to make new friends with today. So thank you once again, really for the decades of warmth and open doors that you have extended to us, to the head table. You have been chief above all in welcoming us to this partnership, and it's truly the honor of our lives to partner with you in this adventure together. And can you believe we are here at our 7th annual plea bargaining conference? We've been doing it longer than 7 years. We missed a couple during COVID. We've probably been doing these since 10 years or so. So we've been doing these together for 10 years, and it's good to be together again. I will try not to bore you with repeating the history that many of you know between Pepperdine and the judiciary of Uganda, but I do have a few new things to tell you, things coming up in the future, as well as some celebrations of those that perhaps we haven't celebrated before. And if I may, my Lord CJ, this morning at breakfast, you made reference to a metaphor. And by the way, may I congratulate you on the new buildings that you've completed. To you and to your team, may I congratulate all of you on the new house for the Supreme Court and for the Court of Appeals. They're absolutely beautiful, and here we are in a conference in your brand new home. And I'd like to use that as a metaphor this morning for this relationship. When we think about what it's like to have partnered all these years, I want you to imagine the steps you go through when you think about building a house. When you first think about building a house, you think about getting an architect, having plans, and building a foundation. And so it doesn't appear that my PowerPoint is yet taking. Some important faces I'd like to show you. If not, I will describe them to you. Well, I think what I will do while they're working on that, these are faces you all know, and I'll simply describe them to you because they're familiar to you. But when we think about building this new house of this partnership in the development of plea bargaining, and we think about who put the plans together and who was the original architect, of course we think of Chief Justice Benjamin Adoki. He and his team, James Agola as his principal judge, and Deputy Chief Justice Butira, who was DPP at the time. These three were the architects of this relationship. They welcomed us, they invited us, they began the process of laying the foundation with a plan for us to begin to do this work together. And so we stand on the shoulders of that foundation. A building cannot be built, it cannot last, it cannot be strong without a strong foundation. And so we owe it to these leaders. Shortly after them, Acting Justice Stephen Kavuma continued on to build the partnership and to grow and to take that foundation and begin to put structure to it. Alongside his principal judge, Justice Yorikam Bemwine, who became one who built the walls around this building and began to erect something that had superstructure to it, something that could be seen and known around the country. As this building was going up and time was passing, Chief Justice Katarebe took the baton and continued to build on the house, to build other floors, to add structures to it, along with his principal judge, Justice Bamwine, who carried on his tradition, who we have affectionately termed the Bishop of Plea Bargaining, who literally traveled around the country. We followed him around the country to prison after prison after prison as he evangelized the country on the benefits of plea bargaining to achieve access to justice in your country. And we saw this house grow and build again and again. And their DPP, Justice Mike Chabita, organizing the DPP, the prosecutors, who had to work hand in hand with the judiciary and with local council in order for all this to work. So in each case, the DPP has played a significant role in building this house. And then, of course, most recently, our very own Chief Justice, Owini Dolo, has continued to put the roof on the building, to put the furniture in the house, along with his principal judge, Justice Saija. Thank you for your work, again, taking the baton from Justice Bamwine and moving around the country to explain how plea bargaining works, building the house, bringing the furniture, putting in the plants, making it beautiful. And has already been mentioned by PJ this morning, the DPP, Lady Justice Jane Abodo, who began as focal person and now continues to lead the prosecutors around the country in mobilizing them to complete this house. And now, as we think about what has happened over these last 15 years or so in this relationship together, we have seen a house built up that people are looking at, that is a beautiful house with a strong foundation, and it is accomplishing these great things we were just hearing from PJ about Mbarara and the incredible, exceptional work they're doing based on this house that has been built, based on the education that you all have taken around the country to create access to justice. It's been an incredible decade together based on the backs of these leaders. But there are a few leaders that we have not, many of these who I've mentioned, we've celebrated. But there are a few, there's a particular time in history, a pivotal moment in history when this began, when the pioneers of plea bargaining began to work together. We look back to 2014, we look back 10 years. And I want to read to you the names of those who were the pioneers to this effort, standing on the shoulders, working alongside the leadership that I've just mentioned. You may or may not recall, but back in 2014, a plea bargaining pilot program committee was formed under the chairmanship of Justice Bamwine, who led a team comprised of Justice Chibita, of Justice Lamek Mukasa, of Dr. Johnson Baya Bashaija, of his worship at the time, now my Lord, Paul Gadenia, and the secretary of that committee was Professor Andrew Hauha. This was the committee that led the pilot program to build this house under the leadership that they've been given all the way back 10 years ago in 2014. Other leaders at the time, Justice Paul Cadena was the chief registrar. Justice Douglas Sengiza was the personal assistant to the principal judge at the time. Justice Isaac Muata was the register of the High Court. They all played a key role in the building of this house. We also know that around that time, or just after that time, Justice Mike Chibita assigned Margaret Nakagude as the focal person for plea bargaining, who has now worked tireless all these years to organize under the DPP the prosecutors from prison camp to prison camp to prison camp. And there were 5 districts that this pilot program took shape. And I'd like to honor those who are on the teams that pioneered plea bargaining all those years ago. And so if you happen to be here this morning as one of those that I mentioned, would you please stand so that we can honor you? And then I'll go district at a time. The first district was in Nakawa, under the direction of the Honorable Justice Lawrence Gadudu. His team comprised of Lady Justice Alice Kamuhangi Hauha as a prosecutor, Miss Samali Wakuli was a prosecutor, Miss Jackie Namazi was a defense lawyer, Miss Susan Sylvia Wakabala was a defense lawyer. Mubinde, under the leadership of Honorable Justice Lamek Mukasa. Mr. Brian Kalanaki was a prosecutor. Miss Esther Nakamate was a defense lawyer. In Mpiji, under the leadership of Honorable Justice Henry Peter Adonio, Miss Caroline Nabasa was a prosecutor. Miss Catherine Namakoye was a prosecutor. Miss Sylvia Namaweje was a defense lawyer. And Mr. Kafuko Ntuyo was a defense lawyer. In the next district, in Entebbe, Honorable Elizabeth Nahamia, may she rest in peace, led a team of Miss Betty Agola, who was a prosecutor, and Mr. Francis Gumis Riza was a defense lawyer. Mr. Henry Cunha was a defense lawyer. And Mr. Isaac Jarugo was a defense lawyer. Finally, in the district of Chiboga, under the direction of Honorable Wilson Museni Masalu, may he rest in peace, was Mr. Ajok Alex Michael was a prosecutor. And the Honorable Alan Shimye was a defense lawyer. These were the pioneers. Can we give them all a round of applause? We stand on their shoulders as we continue to build this house together. Others who we often do not mention by name but hold a critical role in our partnership in building this house together are the prison officials, the officers in charge who take these initiatives to come to their prison, and they mobilize their teams within the prison, and they welcome us and open their doors to be a part. And I want to just recognize a few of them who have been critical to this process. Mr. Wilson Magomu from Upper Prison Luzira, Mr. Moses Sentalo from Chigo Prison, Ms. Stella Nabunya from Luzira Women Prison. Mr. Celestine Twesije from Murchison Bay Prison. And Ms. Namakoye from Chigo Women Prison. We owe you a great debt of gratitude, and we're grateful to the Prison Commission for its partnership in this collaboration. There's one other group that we often also don't recognize. They work behind the scenes. They're nameless and faceless most of the time, but we want to put names and faces to them and honor them today. As part of our partnership, the Ugandan judiciary has provided us with drivers and security in order to move around the country to partner with you in this work. And I would like to read and for us to honor together the drivers that have been working for us these last 10 years. Joffrey Camaras. Patrick Sabunya. Innocent Madiba. Agatha Barunji. Francis Mbazira. Stephen Mugulo. And Musa Muamola. On the security side, Edson Nabasa and Keti Asio. Let me just say, these men and women have been incredible servants to the judiciary of Uganda and to Pepperdine University. They've been hospitable to us. They've taken care of us. We haven't had a single person in jeopardy over all these years we've been in Uganda. They've traveled safely, and it's been an honor to partner with them in this process. And so can we say thank you once again to our drivers. Finally, we've talked about building the house, and now it is built. We've seen the process we've gone through. We've spent many years doing it. And now it is for us, those in this room and associated with us, to maintain this house. If a house that's been built, it's beautiful when it's new, but it will not remain beautiful unless those of us who are here to steward it continue to protect and maintain and serve its purposes. And so we are not looking back, but we are looking forward. We've been to nearly every prison in the country doing plea bargaining camps built on this foundation. And the thing that I want to implore on you as I close this morning is this is no longer, and the Gambia, because of you. You have pioneered here what you've had the courage to try, which is to take traditional African dispute resolution and bring it back to life in modern times, integrated with the modern justice system. All of Africa is watching. Uganda is leading, and all of Africa is watching. And we carry the torch, the honor of partnering with you in this work across the continent. And we will be taking you with us. We will need your leadership. We will need your help to support these other countries. Well, I have testimonies, but perhaps my tech's not going to work. Maybe we can show them to you later. But I have testimonies from those from other countries in March that talk about what they heard about what's happening in Uganda. And once we get our technology set up, we'll play that for you so you can see firsthand what the other nations of Africa are saying about Uganda and what you are doing. With that, I thank you, I bless you, and I pray you have an incredible conference today.
I should say a word. time round made his 30th trip to Uganda. He hates Pepperdine University, and Professor, if you had come to the 70s, you'd have been compelled not to use the title president in this country. There was only one president. Together with Danny DeWalt, they have made this relationship, this family tie, this phenomenon, which we are now helping to expand to the whole of the African continent. This morning over breakfast, I was, whenever you travel by these planes, I normally travel by Emirates. They have a moment of advert. So you see from Dubai, there's a curve.
Rules. So everybody hold this up. In fact, we're gonna get active here. So stand up for just a minute. Stand up, stretch your legs, because you've got to get these questions right. The lives of those who are entrusted to you depend upon you understanding the answers to these questions. Okay, you can have a seat now. We just want to get the blood moving. Okay, so you have in front of you the plea bargaining rules. It's in your folder. Make sure you have it. Everybody show me that you have it. Okay, we've got it. Do we have the ability to advance the frames, the slides? Can we get what's on my computer up here? Is that possible? Otherwise, we're going to have another quiz, which is listening closely as you answer the questions. Looks like we're having some technical difficulty, so you'll have to listen. The first question, and the answer is in your rule book. But I want to hear from you. Some of you already know the answer to these questions before even consulting the rule book. The first question is, true or false? The plea bargaining rules only apply to the high court and not to the magistrate courts. Is that true or false? That's false. How do we know that? Because in Rule 2, it specifically says, these rules apply to all of the courts of the judicature, which is why we have the magistrates here who are now taking the lead and moving the non-capital offenses through the system very quickly. Question 2, true or false? If an accused person wants to plea bargain, he or she must initiate the negotiations. The prosecution may not do so. True or false? False. Uganda wisely decided that this can be either party. Rule 5. If you turn to Rule 5, a plea bargain may be initiated orally or in writing by the accused or the prosecution at any stage of the proceedings before sentence is passed. Question 3, true or false? Plea bargaining in capital cases may be initiated only after the accused has been committed to the high court. True or false? False. We don't have to wait until after committal. It can begin right away. Rule 5 also says a plea bargain may be initiated orally or in writing by the accused or prosecution at any stage of the proceeding, at any stage of the proceeding. I will tell you that in most places around the world that have plea bargaining, lots and lots and lots of pleas are struck before the committal stage, while the person is still cognizant of, yes, I committed the crime, yes, I was caught, yes, I want to own up to my bad decision, rather than waiting and having his or her comrades say, don't admit to it, don't admit to it, say you didn't do it. Question 4. Plea bargaining may, true or false, plea bargaining may consist of a promise to cooperate as a witness for the prosecution in exchange for a reduced sentence or reduced charges. True or false? True. Rule 6b. Look at Rule 6b. A plea bargain may be in respect of a promise to cooperate as a witness for the prosecution in exchange for reduced charges or reduced sentence or both. Remember, sometimes when you have these criminal conspiracies, someone at the very top is the one you really want to get convicted, and so you get pleas of those earlier, those smaller fish, who then testify against the bigger fish, so you can get the major prosecution completed. Question 5. True or false? Where there are multiple accused persons, a plea bargain must be entered into with all accused persons in order to be valid. True or false? False. Of course, we see this all the time. Rule 6, subsection 2. Where there is more than one accused person, a plea bargain may be entered into respect any one of the accused persons, and the subsequent plea agreement shall apply and be binding only to the accused person who entered into the agreement. Question 6. Seems like pretty much everybody here has gotten all of them right. And as a result, that's why we can see, while there was 1,320 of these done in a short period of time in Mbarara, the plea bargaining rules, true or false, apply only to people who agree that they have committed the offense. It applies only to people who agree they have committed the offense. Think about this one. True or false? Well, let's look at what Rule 4 says. Rule 4 says plea bargain means the process between an accused person and the prosecution in which the accused person agrees to plead guilty in exchange for an agreement by the prosecutor to drop one or more charges, reduce a charge to a less serious offense, or recommend a particular sentence subject to approval by the court. So one must plead guilty. Does that mean one must agree that he or she is guilty? In Uganda, the answer has generally been yes. In many jurisdictions, as this process matures, there's developed two different other ways to get to a plea agreement without the person saying they did it. That doesn't seem to make sense, so let me say that again. A plea agreement can be reached without the accused saying that they did that, like a crime. And here's why. Two different areas. One's called, in the U.S., called an Alford plea, where one says, I agree that there is sufficient evidence against me that if I went to court, I could be convicted. So you have the evidence that would likely lead to a conviction. However, I still may maintain my innocence. Now, that's not what every jurisdiction that has plea bargaining does. Why would one do that? I don't want to fight this. I know you have a lot of evidence, but I still didn't do it. But I don't want to go to court because I can plea and agree to maybe 5 years. But if I go to court and I'm convicted, it may be 30 years. So Uganda can think about whether it wants to do something like that. There's also something called a no contest, a nolo contendere plea, where one can say, I'm not contesting the charges. I'm not saying I'm guilty. I'm accepting the guilty plea, but I'm not saying I'm guilty. I'm just not contesting the charges, so that that plea agreement later can't be used against that person for something else. For example, a civil case where someone has sued you for wrongful death and you're charged with murder. If you plead no contest, that no contest plea can't be used against you in a civil case later. Again, these are things for Uganda to consider as it develops and matures its plea bargaining context. But in Uganda, typically it's been the case that unless you say you did it, then you're not involved in plea bargaining. And that is a very straightforward, easily applicable, simple way to do things. And Uganda is very well within its rights to choose to go that direction. Question 7. While all relevant information, documents, and other matters must be obtained, or other matters obtained during investigation should be disclosed to the accused, to the disclosures made, it is not required when doing so would compromise national security, the security of witnesses, or the integrity of the judicial process. True or false? You can withhold some things in order to protect the state or other witnesses. True or false? True. That is correct. Look at Rule 7, subsection 2. Disclosure under subrule 1 of Rule subsection 2 shall not compromise state security, security of witnesses, or the integrity of the judicial process. As you know, Ugandan accused persons have a constitutional right to the disclosures subject to these rules here. Question 8, true or false? A court may not participate at all in plea discussions. Only the prosecution, accused, and counsel for the accused may do so. True or false? False. Rule 8, subsection 1, the court may participate in plea bargain discussions. We'll talk a little bit about why you'd want to do that. Judges, by the training you've received and by the expertise you have, are quite good at mediating. And what plea bargain is just a mediation in the criminal case. So, judges can participate, but there are consequences, as we shall see. Question 9, true or false? A judicial officer who participated in a failed plea discussion shall not preside over the trial in the same case. True or false? True. If you participated in the mediation or the negotiations, you've learned a whole lot about that case, and then if you being, you would not be a neutral arbiter of that dispute if you already knew. That's in Rule 8, subsection 3. 8, subsection 3. A judicial officer who has participated in a failed plea negotiation may not preside over a trial in relation to the same case. Question 9, we're about halfway there. Where a plea agreement involves a juvenile, it shall be executed by a parent, guardian, probation officer, or social welfare officer, or other legal representative of the juvenile. True or false? True. It's Rule 9, subsection 2. Where the plea bargain agreement involves a child, the agreement shall be executed by either the parent, guardian, probation, and social welfare officer, or the legal representative of the child. I remember talking about that one at length when Justice Bamwine and Justice Chibita and several others were sitting at Pepperdine around the conference room table as Justice Bamwine and others were writing these regulations, thinking through all the possibilities of how different courts and different jurisdictions do this, and with Justice Bamwine holding the pen, do we do this or do we not as we create these plea bargain rules? Question 11, true or false? The plea agreement must be explained to the accused by the accused advocate or a justice of the peace in a language understood by the accused before the accused signs the agreement. True. True. Rule 10. A plea bargain agreement shall, before being signed by the accused, be explained in the language the accused understands. Question 12. Before entering into an agreement, the prosecutor must communicate with and seek permission from the victim. True or false? False. That was one of the conversations early on. Does the victim need to agree to it, or does the victim simply need to be consulted? And I don't mean to be simply, but needs to be consulted. And so Rule 11 specifically says the prosecution shall, before entering into a plea bargain agreement, take into consideration the interests of the victim, the complainant, and the community. So that's part of the consideration, but the victim does not have the ability to control or does not need to agree to the plea bargain agreement itself. Question 13. When a defendant has paid an agreed upon amount of compensation to a victim in accordance with local customs, we talked about mataput, the compensation may be weighed as a mitigating factor in the plea bargain agreement. True or false? True. Rule 11 again. Before making a plea agreement, the prosecution shall take into consideration the interests of the victim, complainant, and community, and shall give due regard to D, the interests of the community, and any other relevant information according to E. So the judge may consider these other things. The prosecution may consider these other things, and the judge, when the judge plays his or her role, shall do the same as well. Question 14. True or false? The court must accept a plea agreement even when it's satisfied that such agreement would constitute a miscarriage of justice. The court must accept a plea agreement even when the court is satisfied that such agreement would constitute a miscarriage of justice. True or false? False. Rule 13, subsection 1. The court may reject a plea bargain agreement where it is satisfied that the agreement may occasion a miscarriage of justice. Lots of discussion around the original rules about whether the judge may override the plea agreement and what the actual rules are, what the considerations are. Rule 13, subsection 1 covers this. Question 15. If the court believes the sentence in the plea agreement is too lenient, the court believes the plea bargain agreement is too lenient, the court may accept the plea of guilty from the accused and then increase the length of sentence in the plea agreement. True or false? False. If you have the ability of the judge to increase after the discretion or after the plea agreement has been signed and increase the sentence, you will not have plea bargaining. You won't have it because none of the prisoners will agree to it. If they know what they've agreed to, just can be raised by the judge. So as you see in Rule 15, subsection 2, the court shall not impose a sentence more severe than the maximum sentence recommended in the plea agreement. The court can reject, court has discretion, reject or approve, can't raise it. Question 16. Where the court rejects a plea agreement, the statements by the accused in the plea discussions may be admitted against the accused in a subsequent trial. Again, where the court rejects a plea agreement because it's a miscarriage of justice, the statements made by the accused in the plea discussions may be admitted against the accused in a subsequent trial. False. Again, if you're able to use those against the accused persons, then you're going to have that the negotiations will stop and they will not be engaging in those plea discussions if they're going to be used against them. Rule 13, subsection 2, subsection B. Where the court rejects a plea bargain agreement, the agreement shall become void and shall be inadmissible in subsequent trial proceedings. Question 17. Once a plea agreement is signed by the accused and prosecution, it is a final and binding contract and may not be withdrawn by either party. True or false? False. So we were just talking about that with Justice Zaija. They can withdraw up until the time that it's entered. So look at Rule 14. That's why they were working until 9 o'clock to try and keep them from withdrawing. Either party, Rule 14, either party may at any stage of the proceeding before the court passes sentence withdraw a plea bargain agreement. Sometimes you need to work late to make sure that they all stick with their agreements. Question 18. In conjunction with the plea agreement, the judicial officer, listen closely, in conjunction with the plea agreement, the judicial officer shall calculate the remission the accused will receive and enter that time period on the record. True or false? False. Wilson. Who calculates remission? The courts or the prisons? The prisons. That's built into the structure of the judiciary here. It's helpful for the accused to understand that if he or she behaves in prison, then they can earn the remission, and therefore their sentence will be lower than they agreed to. So if someone agrees to, for example, 12 years with time for good behavior, remission, they may only serve 8. But that's not for the court, that's for the prisons to calculate. Question 19, a completed plea agreement form signed by the accused and the DPP and the judge is all that is needed in the accused file once the plea bargaining process is complete. Let me say that again. A completed plea agreement form signed by the accused, the DPP, and the judge is all that's needed in the accused file once the plea bargaining process is complete. True or false? False. What else? The plea itself, on the record, with all of the things that, if you look in the booklet that you have, flip a little bit farther back, you see the plea agreement, and then you see all of the things that judge needs to do on the record to ensure that the accused understands and waives his or her constitutional rights. Question 20. All of the details of the charged offense must be written in Section 3.0 the summary of agreed upon facts of the plea bargaining agreement form. True or false? All of the facts must be written. It's false. Because remember, you need the facts sufficient for the conviction. If you write all of the facts around this, then you're going to have a longer booklet than I've just handed you. We just need in section 3.0 that the facts sufficient to fulfill the conviction. Question 21. We've talked a little bit about this. Does consideration of culture have a place in the plea bargaining process? It does. It does. You know this, but I want to make sure that you know that we know this. We Americans did not invent dispute resolution. That happened in Africa well before there was a United States. Africa has been engaged in informal dispute resolution for decades, for centuries, for millennia. And this inclusion of plea bargaining into the formal justice system is not ignoring what's happened previously. We were talking this morning, 90% of disputes are resolved outside of court through informal dispute resolution mechanisms that are culturally part of what's been happening here forever. So make sure we understand, make sure you continue to do the things that Africa has done, Uganda has done for many, many years previously, and allowing culture to have a place. Question 22. This relates to the mediator mindset. Does one need a mediator mindset when handling plea bargaining? What I mean by that is someone who is cognizant of the relationships involved and the interest, the emotional and cognitive interests involved in order to effectively resolve plea agreements. Of course, again, this is more natural to you all for the millennia you've been doing informal dispute resolution. And so don't forget about that. Don't ignore that. Question 23. And you can just look to the very front cover for the answer to this one, the very front cover of your materials. The question is plea bargaining a people-centered tool for justice? What's the name of this conference? People-centered. And what we mean by that, of course, is you're talking about individuals whose lives are being affected and the relationships that revolve around the conversations that are part of the plea discussions. And finally, is the process of plea taking in a plea bargain the same as taking a plea in a full trial? Is the process of plea taking, meaning when the person stands up and pleads guilty, the same process at the very end in a plea bargain as it is when someone pleads guilty at trial? In the end, right, you still have to do all of the things that are necessary. If they're going to plead, whether they're pleading beforehand or pleading at trial, they're still going to have to go through the entire process of understanding that they are waiving the rights, etc. Bonus question, final question. Where the court is of the opinion that a particular case is deserving of a more severe sentence than that recommended in a plea bargain agreement, or that it does not satisfy the interests of justice, the court shall reject the plea bargain agreement. True or false? True. If you believe that this agreement, even though reached by parties in negotiations, will constitute a miscarriage of justice under the rules of the Ugandan plea bargaining, Rule 15.3, you must decline to accept. Let me read. Where the court is of the opinion that a particular case is deserving of a more severe sentence than that recommended in a plea bargain agreement, the court shall reject the plea bargain agreement. If you believe it constitutes a miscarriage of justice, you, as those who are delivering justice, are duty-bound to reject that. Well, if I'm the teacher, I was a professor for 20 years of the law school at Pepperdine before I became the president of Pepperdine. If I was grading you, you would all get 100%. Highest marks of all. Thank you for the opportunity to come back. As was mentioned earlier, this is my 30th trip, 30, to Uganda. I love this country because I love the people, because I love what you are doing to deliver justice to your people. And we are honored as an institution, as a university, to be your partner in this. And so God bless you. God bless you. And as Justice Bamwini says, and God bless me too. For God and our country.
Thank you, Professor Jim Gash. Yes, yes.
Thank you, my lord. Just one suggestion, if I may, with your permission. In light of the statistics and the performance that we've heard about the circuit in Mbarara in plea bargaining, may we invite the circuit judges and the team members to come front right now and have a picture with you to honor them of their achievement.
Ladies and gentlemen, we take this occasion to honor the Mbarara team for a job well done with regard to plea bargain as a robust phenomenon in our criminal justice process. I will hand over this certificate of appreciation to head of the team, Lady Justice Kabuma. You make us proud. You make us fulfilled. You give meaning to the offices we hold as people charged with the responsibility to render justice to our people. Congratulations.
On behalf of Mbarara High Court Circuit, we are very honored to get this appreciation award. And I want to thank the Office of the ODPP and our support team back in Mbarara, the support staff, the prisons, and the police. thank you very much for the good job done, and of course, the support that we've had from the top management of the judiciary, we appreciate, and the visits that we've had, because we've had different brothers and sisters. Some are not here, but we've had a number of justices support us. My sister, Justice Abodo, Justice Jane Okuo, thank you very much for always supporting us.
Can I ask the DPP team, Lady Justice, Body, and your team, please, and delete the pictures before the DPP was here, and the one for the record, the one for Memoria, will have the DPP's team in it, yeah. Yes, with your team. The Mbarara team, yeah. Or those who've been instrumental in, yeah. Yes, thank you. Yes. So the circuit is now complete. Please, you can now take the true picture. The other one was a rehearsal. Now you can take. Okay, thank you. Yeah. Okay, thank you. Yes, thank you, please. Okay. So can I ask us to give deserving applause to Professors Jim and Danny? And if I'm not asking too much, you remember the chair and can also applaud the chair for having conducted. Now, I am the final court in the land. There's an application for review that it cannot be complete without Honorable Justice Yorokamu Bamine, Principal Judge. So we will have the entire team come back, because this is a permanent record. My Lord, application allowed, cost in the cause. So please, let me bother everybody. Let's have my brother here. Let's come and take the picture again. Yes.
Huh? No, I want to say something, my lord.
Oh, I thought you wanted to be part of the picture.
No.
Ah, sorry, I got you wrong. But the court of its own volition thought otherwise. So please say so.
But we've looked at Rule 8, Professor Jim Gash. Rule 8.3. There is a red flag in the field out there. The red flag is that the lawmaker used the word may. The judicial officer who has participated in a failed plea bargain may not preside. Well, this is for the principal judge and the Chief Justice as the chair of the Rules Committee. I understand some judge has made a ruling that you don't have to excuse yourself. Yes, a judge of the High Court has said it's not mandatory. You don't have. I would find it rather strange for someone who has had it all to pretend that After all, he did not hear anything and proceed to pass judgment on the accused person. So there is a decision of the High Court. And
Do you want me to say a word about this? In 8.3,
Sorry, Chair. I have also a question. Chair,
Yes,
I also
Justice
have a
Remy.
question on Rule 15, Sub-Rule 3. Says where the court is of the opinion that a particular case is deserving of a more severe sentence than that recommended in a plea bargain agreement, the court shall reject the plea bargain agreement. Now, what is the position where the court is of the opinion that a particular case is deserving of a less severe sentence? Does the court reject the plea bargain agreement also?
But I think the court retains the final discretion.
Okay.
Sit some problem when the judge came up with
with permission of the chair, I'd like to offer a few thoughts. The first is in section 8, subsection 3. I think the question is that the former principal judge raises is an interesting one, and the question may be that it's ambiguous in some way, but I don't think it was intended to be. I remember when we talked through this, the may is permissive, of course, and the shall is mandatory. But the way this reads is the failed plea bargain negotiation may not preside, meaning does not have permission. Though it would be stronger and more clear if it said shall not. Though I think in the context, may not means you are not permitted, which would be equivalent to shall, but it could be misread by someone says, I see the permissive, I'm choosing to exercise my own judgment, and therefore. Whereas where the ambiguity would be completely removed with a shall not. With respect to subsection 15, I think that's a fair question. I know that when these were originally created, the idea was to protect the accused person from not getting the benefit of his or her bargain. So if the accused person enters into the agreement with the prosecution in saying this is the number, then it can't go above that. If the judge says no, that's too high, or so sorry, if that's too low, deserving of a more severe, then they can withdraw it. But the judge was not permitted to say, well, since you agreed to it, I don't think it should be as high, we will go lower. That was also part of the discussion of the accused agreed to 15 years, even if the judge doesn't think that's the right sentence. If the accused has agreed to it, then give the accused the benefit of his or her bargain. That doesn't mean that Uganda couldn't choose to do something differently. Uganda certainly has the ability to say, you know what, we think this ought to be mirrored, parallel. There ought to be, if you can reject it because it's too severe, then because it's too lenient and there should be more severe, then you ought to be able to do the other way around. And so that is something that, of course, those who are responsible for rules ought to be able to consider. But I think the reason was give the accused the benefit of his or her bargain and not interfere on the downside.
My Lord, I was thinking that in that situation, then the presiding judge will resort to 13(1), that the court may reject a plea bargain agreement where it is satisfied that the agreement may occasion a miscarriage of justice. You would apply this.
This is really interesting. The one my Lord DCJ has referred to, if in the opinion of the judge, the agreed sentence, say, of 15 years, is rather high. If the matter were approved, it would have come up with 8 years. Then if it is rejected, then the matter must go for trial. And when it goes to trial, there's the possibility that the state could fail to prove for some technical reason or for some non-availability of witnesses and what have you. I hold the view, and we will consider this, we will debate this, that plea bargain does not take away the court's discretion on sentencing. It only helps the court exercise its discretion. This is how I understand it. So if you agree on a term which is too low, I find if I were to exercise my discretion, I would not come that low. I reject the agreement and say, we're going to put you on trial, and if the matter is proved, then I come with the sentence I thought in the exercise of my discretion I would impose. I should like to think, if you agree on 18 years, and I think it should be 12, in the exercise of my discretion, I should also bring it down and say, yes, there's a plea of guilt. The prosecution and the accused agree on 18 years. In my considered view, it should be 12. Yes. What I've rejected is that agreement, because if we use reject, then you're saying go for trial. Once you use the word reject, then you have to go for trial. I'm only rejecting that part, the sentencing, what they've agreed on the sentencing. Because the agreement, the plea bargain agreement is not just the sentencing only. You agree on guilt. The fellow concedes that they have committed a crime. This is agreed upon. It's not in issue anymore. And then what is the punishment? That's the second leg. I'm saying the agreement of guilt is fine, but the other one is would occasion the miscarriage my Lord DCJ has pointed out. The danger is for a person who, and in the second case where you are bringing the sentence down, the question is, would you be occasioning a miscarriage of justice to the complainants, for example, assuming the complainants were part of the process? And the court says, I think 18 years for a plea bargain is on the high side. I would rather give 12. And the complainants say, fine, we're okay with 12 years. What do you do? My difficulty is if you reject, if you use the term reject the agreement, then you must go for a trial. And anything can happen in a trial.
Or you could reinstitute the negotiations
Thank you.
such that the prosecution says, okay, I'd rather get a guilty plea and 12 than go to trial and fail to prove. And so there's that potential iterative process of a new negotiation happening. And that's not unusual outside of Uganda, is the court says, listen, counsel, to the prosecution, that's just too stiff. You don't have the evidence. I'm going to reject it unless you come back with an agreement that I can sign.
Okay.
And so that's a possible opportunity.
That's a brilliant solution, actually. You say, look, I'm sending you back for renegotiation on this aspect. And then if they can sort it out, fine. If not, then you do the ultimate of rejection, and you go for trial. Thank you. I think that solves it. Yeah. Yes. Lady Justice Dolo.
Thank you, my lord, for
Have I said anything new?
Okay, thank you, my lord. I think there's a solution to what Justice Kasule was raising. We look at Rule 8.1 together with Rule 15.3, which he raised the question on. If the court participates in the discussion, there should not be a problem with how Rule 15.3 is phrased. I'll give an example. I handled one situation where the defense counsel and prosecution counsel came to my chambers and said the accused wants to enter a plea bargain. It was a case of aggravated defilement, and they proposed a sentence. And I said, you know, the child was young. Do you think we should accept that sentence the accused wants to take? And the prosecution said, my lord, by the way, we can't trace the witnesses, so let's go by what the accused wants to serve. Now, by participating in a discussion, you'll not have a situation where you think the sentence is too low, because the state has already told you we may not even have witnesses if we continue with the full trial. So those two rules could be read together. Thank you, my lord.
Honorable Justice Shimia.
My lord, I have a problem with the...
This is the senior one, no, just to distinguish. Yeah.
I have a problem with the constitutional requirement that a trial judge or even a magistrate before sentencing has to take into account the period the accused has been on remand. Now, here is a scenario where the prosecution and the accused have agreed, let's say, on 5 years, and they have signed an agreement. And then the judge goes through the process of plea taking, getting the facts, and make sure that the accused understands what he's saying. And then finally the judge passes sentence. Does the judge say, passing a sentence of 5 years as agreed? Or does he say, you have agreed on 5 years, but I take into account the period of 4 years have been remand, therefore you are walking away with 1 year?
That's the right procedure. That's what the judge should do.
Now, my Lord DCJ, if in the course of the negotiations, like you say, look, I've spent really 8 months on remand, so please bring down and you know, although it is not specifically said, we would have given 16, now we are giving 15. But all this is part of the negotiation. And then you come up with 15 without saying we've taken, arithmetically, we have taken away 1 year. But you know it has been part of the consideration. What would that be a failure? In the circumstance of plea bargain, not where there is that conviction after trial and then sentence. As I said, we will continue debating. Otherwise, thank you so much. We will continue to debate this in our other circles. We thank our two presenters. I'm glad you thanked the chair as well. Now I hand over to the directors of function.
Let us give a hand clap to the chair of the session for steering us in this first session. And let us also clap for our president and vice president, Pepperdine, for the wonderful presentations. My Lord, we are going to have a photo session, and we shall do it in segments. After the photo session, we shall break off for a cup of tea. The high table, the justices and judges present, we are going to have our tea just on my left, and the registrars and all other invited guests, we shall have our tea at level 6 in the restaurant. My Lord, with your permission, I request that you have come and take a seat, and you will be joined by the Honorable, the Deputy Chief Justice, and the Honorable, the Principal Judge. You will also be joined by the Honorable Principal Judge Emeritus. We shall be joined by our elders, retired justices, Paul Mugamba, Honorable Justice Nsimye, Emeritus, Justice Kasule Remy, Honorable Lugadia Tochi, and Honorable Vincent Hurkize. Please, you will come and take a seat. And the first photo session, because of the numbers, we shall have the judges of the Supreme Court present, the Court of Appeal and the High Court. My lords, we realize that we are few numbers, so we shall be all having the first photo session. May I request that you come forward and we take the first photo session. We are taking this first picture, and then we shall have to adjust a bit, and we have Pepperdine on the sitting front. Thank you. I request that Pepperdine comes and... okay? All right. So let us have Pepperdine team and ODPP and advocates present. escort, please come. Let us first have this picture of Pepperdine. Okay. Thank you. Then we shall have ODPP and advocates. That's okay. Prof. So DPP, you have your seat. Our advocates. As registrars and magistrates, you also prepare to come. So registrars and magistrates. Registrars, hurry up, please. Registrars and magistrates, please. Under Secretary, please. Registrars, they are chairs for you to sit. Thank you very much, my lord. We may now proceed for our break tea. High table, the justices and the judges, we are having our cup of tea at level 7 in the restaurant and level 6 for the rest of our invited guests and the magistrates. We are going to the 6th floor in the restaurant. Let us have, we have about 20 minutes. And so let us hurry up and we come back for the next session. We should be back here by 11:30. By 11:40. So we have just 20 minutes. 11:40 we shall be starting the second session. We are already 30 minutes late. So let us be fast and have the same.
My lords, let's begin. Whoever has a cup of tea can continue to utilize it in the conference hall, but we need to catch up on time. We are going to handling appeals on pre-bargain, which would have been a session for 2 o'clock, but we shall do it now and break for lunch. When we come back, then we shall do pre-bargain at the High Court and combine them and move forward. So may I request Honorable Dede Justice Eva Swata, who will be leading us on handling appeals on pre-bargain. My lord, you can go to the podium. Sorry, I've taken over your job, but we shall sort it out after the conference.
Thank you very much, my lord. Maybe I need to know how much time we have for the presentation.
30 minutes. No, we have a full hour.
We have a full hour.
See how you utilize it. We shall close at 1.
Thank you. Yes, my lord, the DCJ, my lords, the retired justices, my lords, justices of the Supreme Court, the High Court, registrars, and our partners from Pepperdine, ladies and gentlemen. I have been introduced. I'm attached to the Court of Appeal. And just to let you know that we do not have a paper prepared for, it is strictly a discussion, because I'm confident that everybody in this room has heard a lot about plea bargain. And we are now looking at the practicals of this animal. And we gave you a problem question, the one of Uganda versus Afro-Yorth. Am I pronouncing it right? Justice Abodo? Can you? Could you teach us? Okay, that name. So I'll just pause for 3 minutes to allow those who are reading it, as I also gather my thoughts. 3 minutes, please quickly skim through it. And as you do so, maybe I can also just give you a brief history of my work in plea bargain. I was a trial judge for probably 8 years, maybe 6, because it started somewhere along the way. And I practiced law as a private practitioner, and my background is in legal defense. So my first encounter with plea bargain was in Jinja. I think it was one of the first places. I think, Danny, you visited us at our scenic lakeside prison. And as somebody who had come from a defense background, it was music to my ears. I had never seen anything like it. The files were, falling at a speed that we knew we could never achieve with trial. So it was at that plea bargaining camp. And I also learned on the job. We learned on the job. In the first years, we didn't really have the rules. So we are working from what Justice Emeritus used to, come around and with professor to teach us. So we understand as those who sit on the bench on the Court of Appeal when we see these mistakes. I did a quick survey of our cases, and probably 20 to 30% of the appeals that are coming in are on plea bargain. It's amazing. I can imagine as a trial judge, your main interest as you write your judgment is to write a fair and just judgment, but at the same time, you have an interest that there will be no appeal against your judgment. Am I correct? Am I correct in my assumption? That you would love, even when you are a trial magistrate. So, lo and behold, a plea bargain is really straightforward. Somebody has come forward, and then it falls because the wrong procedure was used. Please try. We have noticed that most of these mistakes are really careless mistakes. Maybe 80% of those. 10% you can see some deliberate action of the trial officer. And then the other maybe fall in the other 10%. So this is something that can be avoided. It would be saving us needless appeals. Honestly, we should not be hearing appeals on plea bargain because the rules are clear and we also have authorities that are clear. I will, after we have gone through this question, which I know you're reading now, I will give a few of my tidbits of how I used to do it as a trial judge and what I'm experiencing at the Court of Appeal that I hope can assist the trial judicial officers here. Now, the problem question was simulated so that we can know from you, the participants, whether you understand this procedure, and by just looking at this problem question, you are able to highlight what was done right and what was done wrong, because we cannot always criticize. I think the quiz, thank you very much, by the way. I think you're a very good teacher. Yes, you had us spellbound. We are adults, but I liked your technique. Everybody was following, and in a quick flash, we had done the rules without even thinking about it. So whatever he brought out, I believe you are going to find in the problem questions. In the problem question before you of this gentleman, Mr. Afoyoroth, gift. The way we shall do it, I'm not going to pick on people. We can look at, the question here is really, this was a case where the prosecutor clearly did not want the plea, did not want the bargain. They preferred the trial. And interesting, as we had tea, I had some of you try. I have never had that experience. And when I was reading this, I was saying, is this possible? Can the prosecutor prefer a trial? But some of you have told me you've had those experiences. So this is a very good experience. And I could also see there was a lot of exchange between the judge and the prosecutor. And there are so many areas of training that my sister Justice Abodo can pick up on this to take back to your prosecutors. Issues of decorum. I mean, how can this go on in this manner? But that is just an aside. So without much ado, can we look at page 1? And could someone highlight any problems on page 1? The defense counsel has offered a plea bargain. Prosecutor is saying this man is wasting our time. I don't recall whether we knew what the facts were. He killed, okay? He killed the son of that elderly man. Facts are always very important, even in plea bargain. You know that. And that I will discuss at the end. So anybody can offer? We don't have much time. We want to use our hour. Anything? Is page 1 quite okay? Yes, sir.
Page 1 highlights the fact that a plea bargaining can be initiated by any party. Yeah. And in this case, the accused person, through their lawyer, is trying to initiate it. And also number 2, once plea bargaining is proposed, then it would be prudent for the judicial officer to give it a chance, which I think the judge or the judicial officer was trying to do despite the protest from the DPP or the prosecutor in that case.
Okay. The prosecutor is very clear. I do not want to plea bargain. What do you do as a judicial officer? This is one party. Can a prosecutor be forced into a bargain where they have this wealth of evidence that they have laboriously collected? My lords, I'm not very good at names, but of course I know your faces, and so if I don't say your name.
My lord, I was thinking to myself that why does the court belabor and try to have a plea bargain when in fact the accused is ready to plead guilty? He pleads guilty, then in aggravation the state comes in and the other person, the loctus is entered new sentence. Why do you go into plea bargain if the prosecution doesn't want to do that?
My question to you, is there an advantage for an accused person to plead guilty or to bargain? Isn't there any advantage? Who thinks there is none? That it all equals the same? Because remember, this is a rights-based decision for this person. Can I hear some, not mumbling? Can I have a hand, please? Yes. Maybe let somebody who is not you say something. Yes, sir, at the back. You need not stand up. Yes.
I am Mututa Martin on defense. My lord, when the accused person participates in the plea bargain, a sentence that is determined, he's actually part of it. Unlike when a plea of guilt is entered, and it's left court to determine which sentence is given to him. So it is important that he participates, since he has not wasted court's time as one of the mitigating factors and others. His sentence is more comfortable when he's part of the negotiations.
Does anyone have a contrary view? A contrary view? Yes, she does. She raised it.
I have a contrary view because, especially in light of the circumstances of this case,
yes,
where the prosecution does not want to enter a plea bargain, but the defense wants to not to go into the hearing of the trial. In this case, the loctus is always the same, even for a plea bargain. There is a loctus.
Yes.
So I do not see why the judge cannot exercise this discretion and give him a sentence as if it were a plea bargain, if the facts of the case allow.
Okay. Anybody else who might have something to add? Okay, clearly, personally, I feel clearly plea bargain was, like I think one of the presenters said that when they were devising these rules, they were really quite focused on the advantage of the advantage to the accused person. So I believe an accused person who makes the decision to bargain hopes that, you know, I'm not leaving it to the court to decide, because I might fall before a lenient judge, or I might as well fall before a judge, for example, who was a prosecutor. We do usually have we usually have that dichotomy. Yes, my lord.
Yeah, I think what is important to keep in mind is that in a plea bargain, the accused has the opportunity not only to say what he feels should be the sentence, but to accept the sentence that will be handed down by the judge. In a plea of guilt, the accused may appeal for a lenient sentence and give circumstances, but he does not have the final word of choosing the sentence that the judge shall give. In a plea bargain, it will be the judge handing down the sentence he finds appropriate. In a plea bargain, the accused has an opportunity to accept or not accept the sentence.
Yes.
And the judge, in a plea bargain, will take the agreed sentence. It is not his sentence. And that, I think, is significant in terms of justice.
Okay. So I think the other dilemma I could see here was that this is a prosecutor who seems to be adamant. And I believe the rules say, like in any contract, the parties must be willing to contract. So as a judicial officer, if you have that dilemma, what do you do? He's saying, I have a good case. I want you to try this case. My Lord, could you guide us on that?
Yeah, but the judge is given opportunity to get involved under the rules, that he may participate. And in participating, you tell the prosecutor, try it. And then they go and negotiate. Yes. You do not, you are making an appeal to the prosecutor to try it. And I thought what the judge did was proper in this case.
Yes, sir.
When I was in prosecution, you'd meet a case where there was scant evidence. Likely witnesses would not be available, yet you had this murder case. So if someone proposed that they would be in for manslaughter, you grudgingly said, yes, I think we can go ahead and allow it. So this prosecutor, I don't know how much evidence he had, but he should have taken advantage.
Okay. I think it was also mentioned that plea bargain is really ADR under criminal law. So you are now a negotiator. And the judges are saying, learn how to be a good negotiator, a good mediator. A good mediator. Try and impress it upon this prosecutor that let us look at the rights of this man or woman who's saying, I want to plead guilty, but at the same time, negotiate my fate. So it now becomes persuasion. But as you can see, there was a lot of, a lot of hard words. Yes, Justice Abodo.
Thank you, my Lord. I just want to to put into perspective what could have happened here, because it has happened to us many times. That someone can sign up for a plea bargain, and really negotiating is a lot of work.
Yes.
And you negotiate back and forth, you go to the judge says go back, and some of the accused persons, they start at a very, very, you just even think, are they frustrating the whole thing? You say murder, and then they say, me, I am ready to go for only 2 years. They even make it very difficult for that defense there. So this one could have been, because when I read the facts later, you just see that there was a background to this. The person had participated, you wasted a lot of time negotiating and negotiating, and now that I have all my witnesses, he's again saying, I want to plea bargain, and it may again go back to the same thing. Yes, so I think that's where I'm seeing this could have come from.
Thank you.
Yeah.
Anybody else? I saw another hand before we move on. Yes, my lord. Okay. You need to turn it off.
I think sometimes, yes, plea bargaining is just one of the options for dealing with criminal trials. Now, speaking from the prosecutor's perspective, sometimes the prosecutor might feel that a particular case needs to go through a full trial for obvious reasons. It could have been a heinous crime that was committed in that community. Public policy might also demand that there is a full trial for purposes of accountability. So an accused might ask for plea bargain, but I think the prosecutor, depending on the policy reasons, may decide to insist on a full trial. Thank you.
I'll stop that discussion there. Thank you, but we need to move on. But I think you are both correct, and Justice Abodo said you can look at the history and look at the facts. And we are going to go into that discussion. I don't want to really preempt it, but please consider what this elderly man was saying also. This is part of the whole discussion. They also don't want a trial, So when you're looking at policy, sometimes policy, these people are going home and they've already discussed certain things, but it's all persuasion. So you even may have an option to call in the accused person, explain to him his rights, and tell him you have the option of pleading guilty. Because as a court, I think you should, as much as possible, avoid a trial. You are saving time and resources of the state, and you are still going to get, you know, a sentence anyway at the end of it. So you can even suggest that. But if somebody still insists, probably even at the end of such a long discussion, you may not even be able to try this matter, because it looks like already it's loop-sided that there's strong evidence against the accused person which you have been party to. But that takes us to page 2. That takes us quickly into page 2. Can I have some comments on what thoughts can you bring out on those facts and the procedures, where they followed? Some we've already discussed. Is there anything new that has not been discussed? Can we consider let us look quickly at the wishes, or yes, Ms. Justice Elubo.
I think this part here highlights the need to have the victims involved. Now, what normally happens in many of these plea bargains, you'll find that it's only the prosecution which is involved in the negotiations. Yes. That's what happens practically. But in this particular scenario, you see that the father of the victim or the deceased was involved, and he gave his perspective, and at the end of the day, it also weighs in on what the sentence is going to be. But when we have camps, when we have a number of people coming in for plea bargains, sometimes the prosecution is not able to marshal all the victims to be present at the time of the negotiations. But when you do have the victims like this, it is very helpful. So what is do is to ask the prosecutors, if they can't have them there, at least these people have their phone numbers. You can consult them on phone and get their view.
Get their views. Okay, any other matter? I think is exhausted.
To give that opportunity and to give it in firm terms that you must take this opportunity and try to see if there is no way completely of agreeing instead of rejecting it outright. Before the court itself.
Okay. But maybe this is also a lesson to defense lawyer.
Let me add one
thing.
Yes, sir. I also think there sometimes seems to be a perception that plea bargaining should be done when there is insufficient evidence to convict or to prosecute.
Yes.
I think that should not be the case. Plea bargaining should be done under all circumstances where there is an opportunity of reaching some agreement.
That's a fabulous point. Even when you have your big file with all evidence and this man wants to plead guilty, allow him to do so. And because you never know, you might have all your beautiful evidence and you don't convince the court. Okay, so one thing I'm also reading here, please read the file as judges, and that was going to be in one of my points after the discussion. You could clearly see that this judge had not even read the file before. Read it and internalize it, so that as they bundle these sentences before you, you know the facts. You know the facts at the back of your mind and what is best for the accused person vis-a-vis the complainants. Don't keep inquiries. What are the facts? Why do you refer the murder as heinous? Okay, clearly you don't even know how the facts unfolded. Any other comment on page 3, please? Yes, we start with Justice Nshime and then Justice Wolayo.
My lord, I think, well, when you look even at page 3 and page 4 throughout the script, there was a lot of back and forth between the judge and mostly the state. I think my understanding of plea bargains is that if it is traditionally being done and they are bargained, you should have a chance to sit with a judge between the bar and the bench and have a discussion. Something should be ironed out, not in open court. So it would have been, I think, prudent when you realize that there is a heavy position from the state, you could adjourn and have this discussion. But it seems as if they were discussing with all the emotions on the transcript itself, which I think is a bit of a problem in terms of the language being used.
The language.
Yeah.
Yes. Yes, Justice Fulai.
Yes, I actually agree with Justice Shime. These are discussions that are mandated by Rule 8. But the problem is we're not told whether we can do these discussions in chambers or in courtroom. So for me, I usually do these discussions in chambers.
Yes.
With the, with the parties, and so by the time we come to court, really, we have agreed. I mean, everybody knows, what the sentence is. We have agreed.
Yes. And you can see at the end of that page, they come and say, we are all on the same page. You've all been there. There's never been a plain sailing plea bargain, except maybe during the camps when they already come and they're in agreement and the judge has also read the file and is happy with the sentence. So when they came back and then on the same page, the defense lawyer will still go away disgruntled, or maybe the prosecutor will be disgruntled, but you can finally get to an agreement. But I could share with you an experience I had, and we all had our teething problems when plea bargaining was starting, because it was a new thing. And I also one time made a mistake of not reading the files before. I know practically, we say these things, but the volume of work a judge will have to do some of these things. You are being given half a day to clear 100 cases. So preparation is key. So I go in without having internalized all the files. They come in with a sentence, I believe it was 12 years for murder. And I said, okay, fine, they have agreed, and we go through Adan. And as the prosecutor is reading the facts, I started sweating. I had started, I think I read, I had convicted. I had already convicted, I had already accepted the agreement, and then I started internalizing the facts. There it was a heinous, bad murder, it was aggravated robbery and murder. But I was stuck. I was stuck with this agreement, and professionally I had to stand by it. And that was a lesson. Because once you have read and internalized, that is an opportunity to call both parties to your chambers and tell them, I'm looking at these facts. How are your negotiations going? And they will start banding their sentence about. And then that's when you can rein in and say, honestly, be reasonable. The defense, be reasonable. Or honestly, prosecutor, be reasonable. It also helped me in cases of, because even looking at the accused persons, they are accused persons because of their circumstances, they offend. They are women who kill, and they have a reason why they killed. We have the other vulnerable people. We have the offenders who are young. So I had cases where, after reading the file, clearly, this is a woman who had suffered abuse for maybe 15 years. And then I impressed it upon the prosecutor. Please go and revisit these facts. She came back to me the next day and said, my lord, I can't. I even feel 10 years is too much. And so that way you are looking at the rights of this offender vis-a-vis what the state is supposed to do. But I'm quickly looking at page 4, third paragraph. The court says, this is my court. Sentencing is a matter for discretion of the judge. Any comments on that? Sentence. Does plea bargaining take away your discretion? I think it was one of the quiz questions. Does it take it away? Yes or no? Or relatively? Maybe you could say relatively, because you can decline a sentence if you are not happy with it. But basically, you must allow. Yes, Justice Tabodo.
My lord, plea bargaining essentially is done under the table, officially.
Yes.
Because the defense and the prosecution meet outside of the court. So, and then they just come to, like Justice Olayo was saying, you do now, you come and present it to the judge in chambers, and once you have agreed in chambers, then you just go to confirm in court. But sentencing remains the discretion of the court. That's why they said the plea bargaining, the judge should participate in the negotiations. Because that's the point where the judge brings plea bargaining back into the courtroom.
Into the court.
Because if the judge doesn't agree with the sentence, there is no way a plea agreement actually is concluded. They only conclude it after the judge says, I am comfortable with that sentence.
Yes.
So it is still the discretion of the court.
The court.
Yes, my lord, thank you.
Thank you. So now let us quickly move on to the rest. Now the man, yes, Judge.
Has to be set aside. And this is what I read in Rule 15, Sub-Rule 3 of the plea bargaining rules, where the court is of the opinion that a particular case is deserving of a more severe sentence than that recommended in a plea bargaining agreement, the court shall reject the plea bargain.
I appreciate that, my lord, and like she says, ultimately the court has the discretion, because ultimately it is you, the court, who enters the bargain on the record. They cannot force it upon you. And that is why it's very important really to sign this agreement, and those are some of the mistakes we have seen. Because ultimately if you reject it, they already come when they have agreed and signed. You say, I'm not ready to have this. You simply say the negotiation has not been accepted, or they come themselves and say the negotiations have failed, and that agreement, of course, has to be discarded. And in practice, we don't do it, but please, if we could, if possible, like in mediation, keep those two files quite separate. In many cases, when I used to go for trial, I would find the whole proceedings of a failed plea bargain together with the trial. And you are reading everything, and you are biased, whether you are God or... Yes, I'll start with Justice Nshimi.
My lord, maybe just to share, because some of the things that are being considered here, you have to look at what would be the best practice. The best practice is that if you have a session for plea bargaining, you're going to have a pre-session meeting where you agree who is a state attorney, who is a defense lawyer, when are you going to go and all that. Now, there should be a meeting to discuss sentences in the judge's chambers. I remember when I was practicing, I used to go before Justice Lubu. Then you'd say, okay, on this file, what do you have? Now, if there are those borderline cases, we wanted 10, they want 11, or we have agreed 12, or what are the facts, that is when you discuss that. So by the time you go to open courtroom, where you have the accused persons, the victims, and everybody, you're literally just coming to confirm what you did. So your discretion is exercised in chambers. That is the best practice. Although in reality, sometimes when you're handling a matter, especially if it's a camp, then they say, we had some prisoners here who have decided to also plead guilty now. Now, usually that time frame within which to have that follow-up meeting and all that does not arise that much. So you may have a few scenarios where you may end up being in the chambers and they're presenting to you people and they say they have agreed, the agreement is here, and you haven't had enough time. But if you had a pre-session meeting to agree how to proceed, and you had a sentence confirmation meeting in chambers between the state and the defense, you shouldn't really have these exchanges. That is it, yeah.
Do have these pre-trial meetings. It is serving you 70 cases, so why don't you take off a whole day to do that so that you can have a seamless procedure? Mrs. Kisubi, you have something to say? I thought I saw your hand. Okay, there was another hand. Justice Alubu.
Yeah, my lord, I agree with what Justice Nshimi is saying. By the time you come to open court, all these background procedures should have already been done.
Closed.
So you're actually only coming to confirm. And if you follow the procedure on page, in the second schedule, you will not have some of these challenges. Because by that time, you would have already confirmed with the accused person whether that is the sentence which they have agreed. You've already had the negotiations behind the scenes with the prosecutor and the defense, and you will not even come to that point where you say, I now have to set aside the plea bargain agreement. Because in any event, the accused person is supposed to sign before you, and then you seal the agreement with your signature and with the proceedings in court. So it really should not come to that stage where there is a plea bargain agreement, it has already been signed, and you're now finding yourself in a position where everything is sealed, and you're wondering, now how do I go behind this? It should have already been, it should be done step by step, and you will not find yourself in a situation where there's already a signed agreement before you, you've already signed it, you're before the, and you're stuck.
Okay. Now, for the next 5 minutes, just quickly look at page, the next 2 pages should be 5 and 5. 5. Let us quickly look at page 5, and then I'll just have hands, and please just tell me offhand, what do you see as a problem? Where are the problem areas? And then we shall have a quick discussion to wind up. Any problems with the plea taking? Because the judge has now agreed going forward on this.
My lord, I want to take you backwards. Page 4.
Okay. Yes, page 4, 5. Sorry, it's page 4 and 5.
Okay.
Yes.
Where the state says we have come to a plea agreement of 11 years.
Yes, at the beginning.
Including time spent on remand.
Yes.
That's where the judge should have come in to say, leave that to me.
Yes.
You know, because if you agree at this stage that the proposed sentence includes time spent on remand, how will you remove it when it comes to deducting it at the end?
Very good comment there. Any other comment on that page? Any mistake or good attribute? Anything when he says, accused, are you pleading guilty? Yes. Okay, then we do not need to drag this any further. Let me have the agreement. Have you signed it? Poop, quickly. The judge endorsed it. Was that correct? What did he miss out? Let me hear from the magistrate, please. Any magistrate? Behind there? Page 5, 4. The magistrate, the judge, judicial officer said, I'm happy with this agreement. I'm endorsing it. And then told the lawyer, your role is over. Can you please shut up and sit down? Any comments, please? Yes.
Thank you, my lord. Natchez Rachel, Chief Magistrate Mukono.
Yes. I shall repeat what she says. Unfortunately, they were not given microphones.
We can't hear.
Good. You do. Good.
Here, the judicial officer missed out to inform the accused person of their right, that they are going to be waiving their right when entering this agreement. The right to call witnesses against them, and also to bring witnesses to defend themselves, and also their right to appeal against a conviction.
Okay. What about when he entered the plea of guilty? On page 5 at the top. The plea of guilty is entered, I accordingly convict you of murder. On your own plea of guilt. What was missed out? Yes, there's Miss, how can I forget my ginger magistrate? Your name again?
Nyamwenge Immaculate,
Nyamwenge.
Magistrate Grade 1, Nakawa. After entering the plea of guilty, the judge did not wait for the brief facts to be read. He just went ahead and convicted the accused person.
Yes. Anything different? The magistrate behind. What's your name, ma'am? Your worship.
Thank you, my lord. My name is Rita Kidasa. I'm Chief Magistrate Nakawa. My initial observation was the same as Nyamwenge, Her Worship Nyamwenge's, but also I see just referring merely to aggravating factors as per agreement. In our practice, we give them a chance to explain or talk for the judicial officer to listen, because there could be something missing in the agreement.
Oh, good, good.
Thank you.
When I was started, I always wondered why we have, because they've already negotiated and then they are listed. These are these are the aggravating and these are the mitigating, and we are past that. But it's important for posterity that this is what was considered before they agreed, because by then the court has also agreed. I'm sorry, I want to quickly skim through this. Yes.
I think this officer should have explained the rights of the accused. Because when you enter into a plea bargain, you waive a number of rights.
Yes.
And the view is that you should be able to make an informed decision. You might think that in future you want to appeal when you actually waive the right to appeal. Except as regards maybe to severity of sentence. So it is important that the judicial officer explains these rights, and they are laid out in the rules. The right to remain silent, the right to demand a full trial,
They are not.
etc.
They are well known.
Thank you.
Consider those rights. It might look superfluous, but for that accused person, they are hearing about them for the first time probably. Justice Elubu?
I think there's a fundamental problem here.
Yes.
The plea is being taken after the
After?
agreement has been signed.
After the agreement has been signed.
Yes. This person is supposed to have first taken the plea, then you should have gone through the procedure, and then it is only after this plea has been taken and he has accepted, you've confirmed the plea, he has been convicted, then you will confirm these other things, and then sign the agreement. But he has taken plea after you have already signed the agreement. So I think this procedure is all flawed.
He entered the agreement on record without an actual plea of guilty. And we know that the foundation of these agreements is that this person has pleaded guilty. Thank you, Justice Alobu. The last page, the prosecutor, like a child stamping their foot. I'm no longer interested. I'm withdrawing from the agreement because the victim's father, the deceased father, yes, and the accused think we are here for a joke. And he does it after, I think, the conviction is already on record. Any comments on that? He wants to withdraw. The court allows you to withdraw at any time. Was this plausible? Had the judge followed the right procedure? Yes. Justice Wolayo?
Before sentence, that's what the rule says. Even
The
after
law before
says
sentence.
yes.
Okay.
Anytime before sentence.
Anytime before sentence, and it was before sentence, and that means the judge is simply saying, you know what, I'm washing my hands off as Pontius Pilate. Let this go before another judicial officer. Lastly, if we look at the last paragraph, the prosecution is crying louder than the bereaved. And they actually had agreed on 15, he gives 5. I think we have discussed that exhaustively. You cannot change what has been agreed, whether to give a higher or lower sentence. That is open to you to help them in the negotiations to come to a proper sentence. And that quickly takes me back to our court. Like I said, we are receiving appeals on these agreements, and some of the common mistakes, all the mistakes you have seen here. I think this is a live case, I don't know, or maybe they only came up with the characters, but it might be actually a live case. The saddest one is when the judge decides to change the sentence, and some of you or some of us accompany it with even strong language of why they've decided to change. You are going into your wrongdoing with a vengeance. Other problems we have seen, yes, I think Justice Bamwine raised it, the issue of deducting period spent on remand. Leave it to the judge because it's a constitutional provision, and I think this is an area of training for both the prosecution and defense. They sometimes come up with that communication that, my lord, we've agreed on 20 years, including period spent on remand. That is something under the Constitution, and I don't think we can allow these parties to negotiate constitutional rights. okay? And the law is clear. All of you know Rav Gandhi. Do you know the case of Rav Gandhi? Everyone? Okay. It is sad that my senior has left. He was part of that panel. Now, Rav Gandhi said we must follow Article 28.3 to the letter. We deduct the period spent on remand. I think it should also apply, at least that is what we have held, it should apply even for plea bargaining agreements. If this plea bargaining agreement happened before Rav Gandhi, that might be different, before these guidelines came into place. But for the current situation, why even labor it? And when I'm training sentencing, I always tell the trial judicial officers, why labor it? Just do it, because that is a ground they will leap on. You have done a very good judgment on conviction, and they will come to us, and being appellants, they will fish beyond the sentence. And that is creating more work for us, unnecessary. So we have tended to uphold these agreements. Sometimes you can look at some of the mistakes that have been made, and they are not really fundamental. And when you look at the record, what was recorded and what was agreed upon and done, you realize that there was a meeting of minds of both. So we prefer to treat them as contracts. Please, as judicial officers, I repeat this, sign this agreement, because that has been a ground that this is not, it cannot enforce it if the judicial officer. Personally, coming from a defense background, I always thought, oh no, these two parties have contracted, and maybe the judicial officer overlooked signing it. But it will still come as an appeal, and we've held in an appeal that we set aside the agreement, and in fact, the accused person convinced us that it was a harsh sentence, and we reduced it, because we decided now let us resentence. So here is the prosecution losing a good sentence. Proper filling in of the agreement. It is amazing at the agreements we receive. Somebody is clearly not paying any attention to what their contradictory statements. That's because I think you repeat the sentence twice. It is saying something else in one category and another sentence. You find some, there are crossings, clear crossings. You don't know whether it was done in the registry or it was done in court. Lawyers, interpreters, judges are not signing. Because if I was a defense lawyer, I could leap on that this agreement was not explained. It was not explained to this accused person. They didn't know what they were signing. He was speaking Jaruo, and the interpreter didn't sign. And if you read that, if you go back to the record, there's nothing. Okay? They can persuade. And then you've wasted a lot of time. So what I used to do, I would take time off at the end of every session. If I had 4 agreements out of a session, I would critically look at them before they all leave. And then you remind them, you forgot to do this, you forgot to do this. And then you make sure that you're handing over an ironclad agreement that cannot stand an appeal. And then, yes, I've talked about failure to deduct periods spent on remand, forcing the parties into agreement. I think we have agreed on that. That one doesn't usually fly. But you see, the most important thing is, on top of your agreement, let us have a good record, a good, clear, cumulative record. And then we shall know, for example, you followed a done, or you did not. Because once you do so, if a defense lawyer is really professional, they will decline to assist this person to appeal. We have talked about trying to talk to pre-trials and decorum in court, victim participation. I think sometimes it has been understood. We have got appeals where a judge listened to the victim. They had agreed on a certain number of years, and this was a woman. And I think this was a lady justice, and I think because of our training and our sentiments, she then asked her, she said, I feel this man should have been given 30 years. And the judge did just that. After they had agreed on probably 20 or something. And of course, it came on appeal. So, like we said, the victims are important because they are guiding you on what is on ground and what is fair, but explain to them that the criminal justice system just works that way. If somebody has opened up for plea bargaining, we allow them. Just as much as we do not allow the community to take over trials and decide on sentences. We prefer them to come to court and do it in that environment. I've talked about using separate files for trials. And yes, I think I talked about discussing sentences of vulnerability, vulnerable accused persons and vulnerable victims, because you really have to do, you have to do a balancing act. I have those cases. I think 2 were given out to you. Please take time to read them. And I will also share a template. We came up with about 12 recent cases on plea bargain that can be very useful to you because they could be of use to you as precedents. In one, we actually, like I said, where the judge didn't sign, we rejected the agreement. Most of the cases we are actually receiving are those cases where the judges decided on a different sentence. So I'm happy that is something that can be very, very easily corrected with minimal training. Just one last tidbit. As a trial judge, I realized that plea bargaining is good. I will always have a lot of cases before me and I want to be fair. So I created a template. I went to Adan and followed the steps and created a template which I always had before me in court. I could actually take the plea, do everything after we had agreed in less than 10 or 8 minutes. And yet, this template has everything. And I would write within the questions already there so that you don't forget, because it's easy, you're human. It's easy, so you would say, take the plea, explain the offense, and then record the bargain. And I would do it quickly, and then at the end of the day, I would just hand them over to my secretary, and she would come up with a very beautiful document. And then I make sure I have signed the agreement, and all is good to go. So with those few words, I know we haven't covered everything, but we are caught for time. Thank you very much.
Thank you so much, Justice. For the trial judges, really, you now know what happens when the matter goes on appeal. And those are the areas you need to work on before you call it a case. So once again, it's a job well done. Kindly give her another round of applause. And back to the substantive chair.
Thank you very much, my lord, for the job well done. I think everybody has earned lunch. So we should proceed for lunch. If there are any announcements, let them be made now. We shall be here at 2 p.m.
Thank you, Chair, for chairing this session. My lords, your worships and all invited guests, we are having lunch as earlier advised. Justices and judges will remain here, and the rest of the team, we shall go to the 6th floor. Bodyguards and drivers, you have also been catered for, and I will be giving you the exact location. Thank you very much. We may proceed, and we return in time to have the remaining sessions. Thank you. Let's move first for lunch. We strictly have 1 hour, and we shall be back here by 2 o'clock sharp to commence on the third session. I'm requesting we move in fast so that we have the lunch. 1 hour, and we shall be back. Once again, bodyguards and drivers, our lunch is in courtroom 1 at High Court buildings. Bodyguards and drivers, our lunch is at courtroom 1 at the High Court buildings.
Hello? Can we start our afternoon session? Let's take our seats and start the afternoon session. Okay. Yes.
As they come, my lord, since there was this session and there is this session, why didn't they do it together?
No, I thought.
Because we only did this.
Oh, no one.
We only did this. So
Why didn't you do at least two? You should have picked one of these.
this just allowed this one only. So we are thinking if we do this.
No, we are starting with this. Then this next, then this next. When this one is presented, we can skip this.
I have to bring to your attention since you're the chair.
It's okay.
So that you can guide.
Okay. May I have your attention, please? Kindly take your seats so that we can start our afternoon program. I'm about to constitute myself into a court and prosecute those who are standing. Okay, so I welcome you to this afternoon session. We are going to handle session 2, and the way the topics are organized, we thought that we should do the reverse order. We start with pre-bargaining perspective of the prosecution as our first presentation, which leads us to the US best practice and perspectives, and then we end up with pre-bargaining at the High Court. So may I now invite Honorable Lady Justice Jane Francis Abodo, the Director of Public Prosecutions, to step forward and make her presentation. I don't see her though. Ah, okay, yeah, thank you. You can come and make your presentation. You have only 30 minutes, and I will warn you at the 25th. So I will not give you extra time. Thank you so much. I do not have I do not have your CV, but I can give it offhand. Honorable Justice Jane Francis Abodo is the Director of Public Prosecutions in Uganda. She was a judge before she was appointed to that office. She was a judge of the High Court, and she happened to have been the focal person for pre-bargaining in this country. So the rest she can tell you if she wishes, but I thought that CV is enough. But before that, of course, she was a prosecutor before she joined the judiciary, so she's well knowledgeable in matters to do with the prosecution. So you are going to benefit from her a lot if you listen carefully. Thank you so much. Over to you, my lord.
Thank you so much, my lord. I'll just share the plea bargaining from the perspective of the prosecutor. And bottom line, plea bargaining should be voluntary. It should be voluntary, so the starting point is that people who are going to plea bargain should be people who know that they have committed the offense. Then it becomes easier for us to do a plea bargain. So from the perspective of the prosecutor, what we have to do as prosecutors, I do not see them. Where have they gone? Okay, yes. Yes, otherwise we shall prosecute them. Once we have, that's why the chain is very, I'm actually going to give from a camp experience. That's why we have the prisons officers here. They're very, very key, because most of the time they're the ones who actually alert us and say we have a list of accused persons who are actually willing to plea bargain. So what happens is that we get the files. I like this because it helps us do a lot of things as prosecutors. Once we get the list from prisons, we actually straight away start looking for the files. And when we get these files, this is the chance for prosecution to do a weed out of sorts. We read the files and suggest possible sentences. For others, and I've insisted it, that if someone has signed up for a plea bargain, and when you're reading the file, you actually find that there's no evidence, you must advise that the charges are actually withdrawn by either way of a withdrawal or a nolle. I tell them, do not take the chance, even if you feel that this case, since the accused has offered, we should not plea bargain on cases where you see there's no evidence on the file. We should never plea bargain on cases where there's no police file. We should look for a police file, because you'll either do an injustice, because what are you going to be bargaining on? Because you have to read the file, get the aggravating factors, get the mitigating factors, and then offer a sentence that really speaks to justice. Don't also be too, the scenario they gave us, that the prosecutor is being very hard, crying louder than they breathed, and but give sentences that speaks to, which you can actually defend. Because when you're feeling those agreements, you heard from the Justice of the Court of Appeal, some of those agreements are actually filled with so much unseriousness. Even part 3.0, the brief facts, you'll find that the prosecutors and the defense have negotiated, and maybe it was a case of murder. But when you read the facts, you find that no, these people fought in a bar. This is really manslaughter. But you'll find that the brief facts are actually reading still murder. So this should change when you're filling in these forms, the plea bargain agreement, because that's almost the only document that actually you are going to, that can go to Court of Appeal in case the case goes on appeal. And it's always very advisable that when you are filling those agreements, you fill them in three copies. One copy should remain in the file that remains. We call it a PROCAM file. It remains in the office of the DPP. So that 10 years from now, when a victim comes and they're asking for what happened, we can actually go and find that there was a plea agreement made. One agreement goes to the court file, and the other agreement should stay in the police file, because these files are not for prosecution. They actually go back to police. So when you're reading these files as a prosecutor, you take into consideration all those and give an appropriate sentence, so that by the time you go, that's why I like the camp experience. You know, plea bargaining with people who are behind bars is it is not a bargain, because a bargain is like you are all at the same level. So even physically, when you go to a camp, it is a one-stop center. You find the office of the DPP is there. We have our office there, and our secretariat is there, our registry is there. The defense chambers are actually there. And the court is also there with their registry. And there's a cafeteria. So it is a one-stop center. That's why I like the camp experience. And when you're in the camp, you do a lot of things quickly, because the defense and the prosecution will meet together, look at. Actually, that's the chance when the defense get the chance to read our police files. Most of the time, we just disclose to them. But in the camp experience, the defense actually read the files. And then you agree, and the courtroom is right there. You go to the judge. If the judge says this is okay, the judge signs on it. I used to initial, actually, so that the prosecution and the defense don't go and change what we agreed on. Because by the time you go to court to confirm those sentences, most of the things could be changed. And then you find yourself, because then you cannot actually reject a plea agreement in court, because it is understood that you actually do this, the negotiations are done outside the courtroom. That's why Justice Wala was talking about doing it in chambers. You should do it in chambers, the back and forth. If you are not happy with the sentence, don't give them that I want from this period to this period. No, you just say I am not happy with the sentence because it is either too harsh or too lenient. And then they go back. They can actually go back and negotiate the whole week, or there's no limitation until you as the judge. That's why I said, as judicial officers, you actually bring back plea bargain to the courtroom, because the sentence cannot be confirmed without the judicial officer giving a green light. So that is what we should do. And the prosecutors, what you should look out for when you are reading those files. They told you that it is not your work to talk about remission, it is not your work to talk about the time spent on remand. But I think it's a good thing when you're negotiating, have it at the back of your mind, the time spent on remand as well. Have it at the back of your mind. It can help you when you're doing the negotiations. Look at the gravity of the offense. Look at the degree of violence that was used. Maybe it's a murder case. Some murders are so bad that actually as an office, let me now confess, as an office, there are some offenses where, like defilement, aggravated defilement of a victim of like 2 years. And if the offense was done, there was a case where I had a seven-year-old girl was defiled by a 45-year-old man. In a church premises, the young girl had gone to the toilet, the man followed. It was on a Sunday. Defiled her so badly that this girl, her uterus got rotten. In the end, it was removed. The uterus was removed at 7 years. So when the case came up for hearing, the witnesses had come, even that the victim was there, and the accused says, I want to do a plea bargain. I felt like this is going to leave a bad taste in my mouth, because how many years can I ask? Even if I said 40 years, even if we said 45, and I just talked to the lawyer and say, you tell your client to either plead guilty or let the case go on hearing. And I think he pleaded guilty. And so there are some cases as an office, we actually don't, like murders. Who is the victim in a murder charge? Who is the victim? It is the person who has died, and they are not there to talk for themselves. So you find that most of the time, most of these people pay off. I think we should be able to balance custom and then the law. You know, there are some like in Karamoja, if you kill, you know that you're supposed to pay 60 cows, and then everything ends there. And even if you go to court and the case is heard and you're given 15 years, you serve those 15 years, when you go back, you still have to pay the 60 cows. Yeah, that's the justice in Karamoja. There's a man who was charged with, he killed a neighbor's son, and he went to and he served 15 years. He came back and the elders told him, you have come back? He says, yes, I've served. Say, now the case you left so many years ago. And he said, no, I've served. I was sentenced. They say, sentenced by who? We have been waiting for you. We have been waiting for you. Sentenced by who? We are not aware. So the man refused and actually was killed. Very sad. He was killed within a week. So I think we also have to balance the things, custom and the law. And now that we are going towards alternative justice system, those are some of the things that we have to pick out. What are the things that we have to actually tell the community that some of these offenses, we can't plea bargain, we can't do them alternative justice system, we can't. Defilements of very young children, very bad murders. As an office, we actually can't plea bargain on some of those. So the age of the victim definitely plays a big role, and the age of the accused person. You'll find that in a defilement case, you might find the accused is 19, the victim was 15. We can be lenient in a plea bargain. And also, we should look at also if the offense involves loss of money. We must make sure that we do some compensation. How much money was lost? How much can an accused person? And we have to be very careful in this one, because then as prosecutors, we cannot follow up debtors. It becomes a civil case. So we have to be very, very careful how we actually get this. And there are some cases where an accused can actually do a plea bargain and they become our witnesses. We should also be looking at those. And then also where an accused has a previous criminal record. It's very, very important, because then you don't want repeat offenders. They say that I'll commit the offense, I'll do a plea bargain. After all, I know how many years I will get, at the end of the day. And of course, we should look at also the willingness of an accused. I've already talked about that one. Public interest. It's very, very important when we are also handling these cases. It may be that the particular offense happened and the community was maybe shocked by it, or it had really, the effect on the community was so negative that you do not want to just wake up and say you're actually plea bargaining this particular case. The accused person, after 5 years, they do the time spent on remand, 3 years, and then prisons calculates remission after the 2 years, calculates is coming out after 8 months. And of course, very, very important to have victims participate. They're not the final people. They are not. We represent the interests of the victims, but the victims should participate in these plea bargains. That's why it becomes very difficult when we do a camp. But we have managed to do a camp in Masindi and Gulu. And we had a victims tent, and the victims really came. So as we plan for the camp experience, I think I have not seen it happening in Kampala. But it is very, very important that victims are actually involved in these plea bargains. Because then at the end of the day, we want the accused persons to go back to the community and live with these people. If the victim is there waiting to be called as a witness, and they see an accused person after 2, 3 years, and they have come. And it's also important for the victim to understand that in your case, the case was not really very strong. That's why we had to go for a plea bargain. It would go either way, so that they understand why did you come up with a very lenient sentence. Because for them, they believe if it is defilement, they have seen people being convicted to 30 years, even 40 years. So why is mine walking away with 5 years? Then you say, no, the victim was not very young, 14 years, and the accused was borderline. When you see an accused, when they have written the age of an accused as 18, then you just know that the person must have been younger than 18. because most of the time when the accused persons go to prisons and to police and they ask, how old are you, 16? They just put 18 because they want them to take them to prison. And of course, they know that when they say they are lower than that, then they are taken to remand homes and they are out of prison very fast. So we have to balance all those things as prosecutors. So I really, that is from the part of the, but this conversation cannot be complete. We should have had a part of the minutes that I have for the defense, because most of the time, my lord, the defense do not do their part. The accused persons, they don't explain to them that you are doing a plea bargain. First of all, you have to do it voluntarily. And you have to enumerate to them their constitutional rights that they're actually going to forego, all of them, so that they actually they take up the plea with intelligently, knowingly that actually I'm doing a plea bargain, so I will not call any witnesses. So that by the time they come to court and you're asking them, did your lawyer explain to you your constitutional rights? And when the accused person is trying to say no, the lawyer will just be there shouting, no, 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 say yes, and you just feel so bad, and you say, but do your part. That's why even if it is in the criminal division, let's imagine that you want to do plea bargain in the criminal division. We used to get a day and get production warrants for like 20 accused persons who want to do plea bargain, so that they can interact with their lawyers in the courtroom there, and then they come the next week to do a plea bargain, so that you get time to explain to them. By the time they actually get into a plea bargain, they get there knowing that I'm entering into a plea bargain. But you find that most of the time, most accused persons just get in there because the lawyer has said, you do it. And also there's a complaint, my lord, in the field. The prosecutors say that most of the judicial officers don't follow the procedure. And when they inform the judicial officer that the procedure is not really being followed, I thought after this it should be Adan versus Republic, and you go through and say, no, no, no. And some even don't write. There's no court record. They say that I think their research assistants or what fill this afterwards. And these are some of the things that get us when we reach Court of Appeal, and we don't have anything on the court record. The plea agreement does not replace the court record. It doesn't. We must have a court record, so that at the end of the day, you actually have followed the procedure, and then another thing is that most of the judicial officers now want to, I don't know whether it is funding, but people prefer plea bargain to actually normal sessions. So we went one time to do sensitization in the prisons, and the prisoners asked us and said, how about us who are not innocent? When are you coming to listen to us? How come you only want those ones who are guilty are the ones you want to handle? So I don't know whether it is a problem of funding, but of course we want plea bargain but I think they should not really replace sessions. I think we can have more plea bargains if we also have sessions at the same time, so that the people who actually plea bargain are the people who want to plea bargain, not that they are forced to plea bargain because they're just tired of being in the prisons. So my lord, I don't know whether I still have time.
No, if you can save time from you, I have no problem.
Yes. So I think that is the perspective from the perspective of the prosecutor. That is really what I can say. But otherwise, I have the prosecutors here who have been doing plea bargain for a very long time. And if I've missed out anything, but basically that's what we as the prosecution, that's what we should be looking at. Please plea bargain and do it fairly. If there's no evidence against an accused person, don't allow them to plea bargain. Let's withdraw it from the system and let the people go home. Thank you so much, my lord.
Thank you, my lord, the DPP. You've had the interplay between custom and modernity. So apparently, I think when I was in Karamoja, they said there is a difference between killing a man and killing a woman. If you kill a woman, it's 120 cows. I thought we should emphasize that for men who are around. So they know how dangerous it is to kill a woman. Okay, thank you so much. We have saved at least 5 minutes from you. Let's go to our next presenters. That is Honorable Judge Williams and Scott List. I don't know how you are, who will begin. Okay, fine. I must apologize, I was not given any CV. But maybe you can do me a favor by at least highlighting who you are so that people can know who is talking to them. Thank you. You have 30 minutes. But I can lend you the 5 Jane left behind.
Good afternoon, my lords. Thank you so much. For those of you that don't know me, my name is Scott Leist. I don't really have a title beyond that. I work for Pepperdine here in East Africa, doing daily plea bargaining and public defense out in some of the magistrate courts. Are you having trouble hearing me? Is that okay? Okay. And I'm privileged to be here today. They titled our presentation, The American Perspective on Plea Bargaining. We're going to deviate from that a little bit because that's a bit boring. I think we'd just like to talk about maybe some of the things that I've experienced, and the gentleman to my left will talk a little bit about some things that we together have experienced just in many years of practicing criminal law in terms of plea bargaining practices that just seem to apply everywhere, that just seem to be pitfalls and challenges that in whatever country you're in, not certainly unique to Uganda or the United States. So to my left is a gentleman named Matt Williams. He is a former district court judge and superior court judge in Washington State, where I'm from. I know that every time I tell Lady Justice Obodo that I was a prosecutor, she sneers and doesn't believe me, because now I'm a defense attorney. But this gentleman can affirm that I was a prosecutor because I practiced in front of him as a prosecutor and as a defense attorney. Judge Williams is very experienced. He was on the bench for the better part of 2 decades, had a long career before then in private practice working for the government as a lawyer in Iowa. So I'll let him fill in the blanks that I'm sure I've gotten in his CV.
I started as a prosecutor in the state of Nebraska, where I handled, among other things, capital cases, and then was also prosecutor in the state of Iowa. And then my wife and I made the journey to the West Coast, where I had the great privilege of being able to work with and learn from my good friend, Scott Leist. I've said this several times today. Whenever Scott, whether as a prosecutor or as a defense attorney, walked into my courtroom, my blood pressure went down. And the reason for that is that I knew that whatever was going to happen, whatever was going to come from his mouth, I could trust. I could trust he was going to tell me the truth. I could trust he wasn't going to shade anything. I could trust that he was going to be trying to do something fair. Now, he didn't always get what he wanted. Sorry, Scott. But as a judge, taking, among other things, and taking pleas, and then doing the sentencings that related to those, knowing that there was a person in the room that was prepared, had read the file, and was going to give me the unadulterated truth, no matter whether or not it hurt their case, his case, or the other side's case. Knowing that I had that trust, that relationship, that was a very positive and powerful thing. And of course, in your courts, I know that you're facing, I was just listening very carefully to my lady, and it's very clear having the ability to have those conversations as a prosecutor to defense counsel, as prosecutor and defense counsel to the magistrate and to the judge, invaluable. And it's also what we see in U.S. practice, that and I can share with you, just 2 weeks ago, I'm on senior status, so I still get called back periodically. Just 2 weeks ago, I refused to plea. Why? The defense counsel didn't do their job on the very issue that my lady just talked about. So many of the challenges that you're facing, we're facing too. They're, as Scott said, they're universal.
I think what I try and do in any situation, in any room like this, is I try to begin with some things that we can agree on. Now, I was a prosecutor, a defense attorney, now you're judges. Judge Williams is a judge. There's prison officers here, maybe even a few police officers in the room. So I think we come from different perspectives. But I think we can agree on a few things, I hope. The first thing I'm hoping that we can agree on is not every case needs to go to trial. Can we agree on that? That there are many, many, many cases that are filed. And some of them they look terrific at the beginning and then you realize they're not so good. Some of them look terrific all the way through. Some of them are so good that from the defense perspective, we don't feel like it needs to go to trial. But can we agree that not every case needs to go to trial? Can we agree even further that the majority of cases don't need to go to trial? Are there folks that agree with that? That probably most cases that are filed can be resolved short of trial? Okay. So I think the defense, the defense bar, the prosecution, and judges, I think, can agree on that. The second thing that I think we can agree on, and I heard Lady Justice Obodo say this so beautifully, that while we want the public to be involved and we want victims to be involved, they're supposed to be involved in both of our systems. There's a rule in the United States, at least in the state where we practice, called the Victim Bill of Rights. The victim has certain enumerated rights to be present for hearings, to speak before sentencing. So victims are important, the public is important, but can we agree on this second thing? That the litigants probably know the most about the case of anyone. Okay? We can agree. Can we then take it one step further than that and say that the prosecution and the defense probably know the best about whether the case can be proven? Because the judge doesn't know if a case can be proven until you start telling them the facts of the case. So can we agree that when you've got a prosecutor and a defense attorney in front of you, those two people probably know whether the case can be proven or not better than anyone else? Okay, but then what do we do with victims? Because they have strong opinions. It's a challenge. So, but I think we can agree that the litigants generally know the most about their cases, and again, not every case needs to go to trial. And the third thing I'm hoping we can agree on is, can everybody in this room agree that trials are uncertain? Of course, that's why we have them. Can everybody in this room agree that evidence, I'll use the word fragile. Maggie, Nachagudi, how many times have you looked at a file and the evidence seems very strong and then over the course of time it evaporates, it changes, it disappears? It happens. Yeah? It happened to me as a prosecutor as well. You first open the file and you think, this is great, I'm going to have no problem proving this case, and then a month later you're dismissing it. So evidence is fragile. Can we agree on that? Which means that, trials change, proof changes, which is why they're uncertain. And then finally, when we agree on this last point, that litigation is expensive. Can we agree on that? Not just the money. You guys know about the money. But Justice Obodo, you were talking about this 7-year-old that you had to put on the stand to talk about what had happened to her. That's expensive for that victim. That's costly. That's damaging. So can we agree on those things, even if we're opposed to each other in terms of defense attorney and prosecution? Okay. And I think there's one thing before I turn it over to Judge Williams that I think we can also agree on. I love looking at appellate court opinions. I look at appellate court opinions the way I look at the Old Testament of the Bible. So much of the Old Testament of the Bible is a story of God's promised and chosen people doing the same
dumb things over and over and over. And you almost read the Old Testament and it's almost like watching a horror movie where you know what's going to happen. You want to stop and say, no, we know how this is going to turn out. Don't do that. That's what reading these appellate opinions is like. But we still have a court of appeals that's very busy. So the defense still keeps making the same mistakes we always make. The prosecution keeps making the same mistakes they always make. Judges make the same mistakes they always make. Even though we know how the story ends, we keep doing it, which is why this room, I'm so grateful to be in this room with all of you, because I hope that as we move through the rest of the day, I think the Lady Justice from the Court of Appeals said, I wrote it down because I've never heard an appellate court judge say this, we should not be hearing plea bargain appeals because they're just really careless mistakes. So how do we avoid those? Judge? Well, I wasn't posing that question to you. I totally put you on the spot. So how do we avoid those? Well, and I've been asked to speak into the mic so that the online audience can hear us. I want you to know that before this began, speaking of costly mistakes, Scott and I flipped for who got the mobile mic. I did not win. So,
I'm going to go over here.
Bless your heart.
It's like using the mic.
So how do we avoid costly mistakes? I suspect, and in reading through the statutory instruments and in reading through the court rules that relate here in Uganda, I saw the similarity between the very same court rules that I'm charged with applying. There's some differences, but I also, as I was listening to my Lady Justice Aboda and your other speakers today, I was struck by how there are 3 words that are part of our checklist. 3 words that should resonate with every judge. 3 words that should resonate with every prosecutor, and 3 words that should resonate with every defense counsel. And those words are knowingly, voluntarily, and intelligently, and the things that underlie each of those things. So when we're looking at those cases as judges, and I submit to you that as a judge, I am doing what I heard, and I'm not even going, it was the judge that was from the Court of Appeals. I'm doing exactly what she suggested that we do. We start with the objectives of plea bargaining. The reason why we're doing this, and by we, I don't mean the defendant. Okay, look, the defendant just wants to get out of jail. Okay? At the end of the day, 90% of the time, they just want it over. Are we doing it out of a sense of punishment and retribution and an eye for an eye? Well, you know, certainly in our community, there may be those, but I go back to the objectives. The objectives are to enhance the efficiency of the criminal justice system, to facilitate reduction in case backlog and prison congestion. And there are some that say that's the only reason why we do it. They're saying that, in fact, when you look at studies, and I'm aware that they're here in Uganda, you have done studies that both in 2017 and most recently in 2023 that deal with those very issues. We just completed a study in the United States on the same issue through the American Bar Association. But that's not the only reason we do it. Look, it's one of the byproducts, but that's not the reason why we have plea bargaining. To enable the accused and the prosecution, in consultation with the victim, to reach an amicable agreement on an appropriate punishment. Oh my gosh, I was just listening to the story of the man who returned to the village, and within a week he was dead. And I was thinking to myself, in a vehicle of transparency, of community agreement, this is what plea bargainings are supposed to help us avoid. To provide quick relief from the anxiety of a criminal prosecution, yeah, okay, get out of jail. To encourage persons to own up to their criminal responsibility, and this one, which is what Scott was just talking about. To involve the victim in the adjudication process. When I'm listening to a plea, and I'm taking a plea, I have a checklist. And so the answer to Scott's question, in the United States, it's a checklist to make sure that we have covered the waiver of each right, that we have covered issues concerning whether or not the plea was coerced. If they think that they're getting something that they're not, they've been promised something, they've been coerced, they've been threatened into doing something, and it's on my checklist. Whether or not it's knowing, do they have defense counsel? Have they been completely informed not only of the potential penalties going to trial, the penalties that they're agreeing to, but have they also been informed of the collateral consequences? In the United States, a big collateral consequence are the immigration factors, because a conviction, even a low-crime conviction, a misdemeanor conviction, can subject the defendant to deportation, exclusion from the United States, or denial of naturalization. And so there's an entire part of my checklist, a litany, that not only am I confirming on the record, directly with the defendant of those things, I'm looking at his lawyer, and I'm going, sir, have you complied with your obligations? We have a specific case that deals with this. And I get the lawyer to tell me, oh yeah, I talked this through with him. So the answer to your question, Scott, and I submit to you, here in Uganda, you have, I think, this amazing checklist that's built into your court rule. Answer your question in the United States, it's checklists. Make sure you cover it, make sure you ask the questions, and of course, it's helpful if we actually read the stuff that gets submitted. Scott, how often do you find that you have situations where somebody hasn't read the file?
Well, this is, many. I'm going to answer that question in a little bit different way. I've practiced all over the world, and I think what we know about criminal justice systems that work is they're not necessarily populated by powerful people or people of equal power. What they're populated with are people who trust each other. And I'm going to give you an example. In plea bargaining, and I just am looking at my Lord Bamwine about this because I can hear this coming out of his mouth. In plea bargaining, the parties need to work with and trust each other. The parties need to understand that it may seem like they're giving up a little bit of their rights. The judge may seem like they're giving up a little bit of their discretion. The prosecutor may seem they're giving up a case that they could take to trial. The defense is giving up the opportunity to take a case to trial and cooperate rather than being, adversarial. But once you get past that initial fear, and I'm so privileged to see it every day here in Uganda, it is amazing how many cases you can resolve. Going back to the first thing that we agreed to, not every case should go to trial. You can actually get rid of the cases as a defense attorney that you know you're going to lose at trial. You can give your defendant the benefit of reconciliation. You can give your defendant the benefit of not having to go through trial, and obviously a better sentence because you're saving the court time. From the prosecutorial perspective, of course, you may frustrate a victim. A victim might not like the fact that you're making a decision they wouldn't. And so you're giving up a little bit of your power. You're potentially giving up some years in prison. You're giving up punishment. If that's what you think as a prosecutor is your sole job, you're giving up part of that. But you're also getting rid of cases. I think Justice Obodo has 168 hours in every week. That's the same amount of hours that I have. And if she can get rid of cases without having to go through trial, yes, she's getting rid of those cases, but she's freeing up some of those 168 hours to do what? To take the cases to trial that have to go. So you're actually increasing the resources that you can put toward cases that deserve them or need them. And then from the judicial perspective, I've practiced in courtrooms all around the world, and one thing that I know about judges, and when you roll into court in the morning, there is a big stack of files waiting for you. You are going to have a difficult time finishing your work that day. Even if you work quickly, even if you work efficiently, you're going to work through lunch, you're going to work until the end of the day, and you're probably not going to finish. That pile is going to be waiting for you tomorrow, and it's probably even going to be bigger. So it's so gratifying to see my teams and the prosecution teams that we work here in Uganda break through to that point where they trust each other and are able to resolve cases so amicably and so efficiently and so many. Just to give you some statistics, the team that I have out in Makono, not that I have, that you have, it's Pepperdine team, but I don't practice, I just run around after them. That team resolved 3.5 lawyers, 3 lawyers and 1 part-time lawyer, resolved almost 2,200 cases last year. And of those cases, almost half of those people went free. They didn't go free because they were innocent. They didn't go free because the cases were dismissed. They didn't go free because some tricky lawyer got them off. They went free because they'd either served their time or they had taken responsibility, which the victims and the court appreciated, or in looking at the file, these 2,000 files, sometimes the evidence is fragile and the cases become more difficult for the state to prove. So that's just 3.5 lawyers in one district over the course of a year. But the gratifying thing is we're here talking about how plea bargaining doesn't work and when things fail and when colloquies go wrong and when the Court of Appeals has to get involved. I want to say that I'm privileged to have the opportunity every day to watch it go well and to watch it go right. And when it does that, it's amazing. It's just amazing to watch these adversarial parts of the system work together and do justice. So I'm not sure if I answered your question.
Yeah.
No. Yeah.
Hey, can we talk for a second about victim and family involvement? Now, you know, there's a big difference. Well, there are 2 significant differences between the way the Uganda process works and the way the U.S. process works. The first is built into your court rules. Once you approve, once your magistrate approves the plea, that's the deal. You can't go up. You can go down, but you can't go up. So you have discretion to go down, but you can't go up. One difference in our system is the only thing that the individual is getting from their plea is a recommendation that the judge is not bound to follow. So in other words, the judge isn't bound by the sentencing recommendation. It can go up, can go down. There's some other restrictions on what judges can do. And that is a difference between our systems. It's only kind of half of a difference because you still have discretion to go down. Now, of course, the other big difference is we have very strict what are called speedy trial rules. And that puts pressure on prosecutors that does not, there are already enough pressures on prosecutors here in Uganda, but that is an additional pressure that our U.S. prosecutors have. But that issue of, well, where does the victim statement, I mean, the defendant has the right to allocute. The defendant gets to say something, right? So what do we do when we have family members and we have victims and they want to say something? Whether, like according to the hypothetical you received earlier today, they want the sentence to go down or whether they want it to go up. Well, you know, I got to tell you, I go back to those original statements of the objectives. And again, our job here, the job of the judge, the prosecutor, the defense counsel, it's not just to clear cases. That's an important thing that we're doing. But it also provides some catharsis. It allows the communities to move on. And so I'm going to suggest that one of the aspects that we use when, and frankly it doesn't happen very often, we have a victim, an identified victim, that wants to say something, even though, you know, the reality is I'm going to follow what that recommendation is, we let them. Because the voicing of that is sometimes what they need in order to be able to heal. And so, of course, that goes back to being able to make sure that, and again, going back to the hypothetical that was presented earlier today, everybody kind of understanding what their role is. So if the prosecutor believes that the case is theirs and theirs alone, then the trust that Scott was talking about cannot exist. If the defense counsel has only one thing in mind, and that is that they want to push the case forward to a hearing, then that trust is not going to exist. And if the judge is not going to make sure that the defendant's rights, and say the words on the record, that the defendant's rights are maintained through the checklist, well, again, the trust becomes a problem. So I just wanted to, talk about this idea that the challenge that you face, and where there's an objection to someone speaking, well, sometimes, yeah, it can take a little bit of time, but sometimes you've got to acknowledge, whether it's the defendant, whether it's the prosecutor, whether it's the defense counsel, sometimes you've got to just acknowledge, okay, you just need to get this off your chest and then we can move on.
I know we're almost out of time, so I'll say one last thing.
You still have 10 minutes, sir.
Nope, we're going to give time back. Because you guys all, if you've heard me speak before, you know I follow the 5 Bs. Be brief, baby, be brief. So,
whereas I'm an elected official and I can talk for hours and say absolutely nothing.
There's a reason why he doesn't have this microphone.
Yeah.
He'll take it back to his hotel with him. So the last thing I'll say, and I think what we've spent here today, and I understand why we've done it, is a lot of time it kind of encouraging people to stay in their lane. We say to judges, okay, make sure you do this judge stuff correctly. Make sure that you fill out the form correctly and listen. If you're a defense attorney, make sure that you tell your client about their rights and that they're knowingly waiving them. If they're a prosecutor, involve the victim. So we spent a bunch of time talking about how we can each do our jobs and our individual roles better, and that's incredibly important. But I want to suggest something to you. I think the next level for any legal system, and my legal system in the United States is still working on this as well, is when you build up a level of trust where the participants in the system begin looking out for each other. So for example, I've been in Judge Williams' court, and he was giving an example before of, okay, Scott, I need you to make sure that you have advised your client about these things. Now, that's not his job. He's not going to be embarrassed if the case is overturned because I haven't done something. But he is, because he's presiding over it. So he takes responsibility for making sure that I, as a litigant, or I as a defense attorney, am doing my job well. I've had prosecutors do the same thing for me. I've said the same thing to prosecutors. Listen, I just need you to know that I think the victim is going to go sideways on you. And if we have a deal, we have a deal. I can't have you coming to court and listening to the victim and then changing your story. So kind of encouraging, helping them do their job. I've had judges say to me, Mr. Leist, I don't think you've made your record well enough. I need you to explain to me on the record exactly what you told your client about this issue, because I want to make sure that this doesn't come back on appeal. And that's when you know that the trust is there. When if you as a group, as you as an entity, as a court, decide that you want to resolve a case, that you're looking out for each other and the issues that we know are common to each side as you do that. So I'm pleased to be here. I know Judge Williams is pleased to be here. We're grateful to be in this room with all of you, and I yield my time back to the chair.
Thank you so much for that wonderful presentation. Our take home is checklist. Make sure you tick every box to avoid an appeal. So both the prosecution and the defense counsel and the judge kindly tick all the boxes before you complete the bargain. Thank you. So that brings us to Uganda, and we are going to listen to Honorable Lady Justice Henrietta Worayo. Lady Justice Henrietta Worayo is a judge of the High Court, and she's currently the resident judge of Ruwero High Court Circuit. She has a substantial experience in plea bargaining. She has been a serving judge for quite a while, and she's a career judicial officer. So, over to you, my lord.
Thank you, my lord PJ, my lord the DCJ, and all protocol observed. So this session, we are going to look at plea bargain process in the High Court. It's not so much that we are going to look at the actual process, because I think we've gone over this throughout this morning, But the scenario that you have there, scenario number 2, please take a look at it. There we are called upon to discuss, the trouble spots or the dynamics of the plea bargain process, from the perspective of the bench, the bar, and prosecution. So my lords and worships and everybody in the room, colleagues, I don't know that you need like 2 minutes to read the scenario. It's a very brief one. This is a woman called Happiness. She was married, and then this husband disappeared. After some time, the body was found somewhere in the gardens. And later on, of course, the facts that emerged were that, she had fought. The husband came home drunk, hit her with, they started fighting. Then the sons came in, and he was hitting her with the flat part of the panga, and somehow, he was killed. So those are the brief facts of that case. So the first question that I would like us to look at, it's there if you see that problem question. Your Worship Buchanan, can you help me to read the number 1?
Question number 1, scenario 2, could Happiness have been assisted to get justice faster under plea bargain since she admits to the crime from the point of her arrest?
Yes, if you've read I missed out this bit. If you read the first part of the second part of the scenario, this she took 4 years to get before the judge. I mean, okay, for 4 years she's in prison. She wants to plead guilty, but somehow she's not getting a chance to bargain. So how can we assist? How do you think this lady can be assisted? She wants to plea bargain this case. So why has Happiness actually failed to get on this list of plea bargain? Because she has been asking, I want to plea bargain, but nobody is, somehow she's not getting. So what is the problem here? We heard in the morning about, list coming from prison. Why has she failed to get out? Any responses, my lords, who have faced this kind of scenario? And your worships? I don't want to be the only one speaking. Yes, I can see. Honorable Bako, please.
Yes, thank you, my lord. I think from the facts of the case, the prison staff, they are saying that she had to be committed first before she could be given an opportunity for plea bargaining. So it appears there was that problem, that the committal proceedings, I think, must have taken long to commit her, and therefore she was denied that opportunity. So if we go by the rule that plea bargaining can be done at any stage of the proceedings before a judgment, she could have got an earlier opportunity for plea bargaining.
Yes, you're very right, Honorable. Thank you. Any other response? Yes, my lord.
Mine is kind of like a response, but a question. I'm responding in form of a question, coming from Honorable Bako. If you have not been committed to the High Court, that's what I thought, or I'm also still thinking. I'm yet to buy into the idea of Honorable Bako. You have not been committed to the High Court. I think that somehow the High Court has no jurisdiction over you. From what I read the criminal law to be, not that I'm an expert, but I'm just learning. And then because as well, when we do plea bargain in the courtroom, the prosecution will put some pieces of evidence to support their case, For example, the medical report, the post-mortem report, and all those things. Now, at this point in time, the ODPP has not yet finished investigations. Therefore, they have not committed. Therefore, what evidence is going to come for somebody such as Happiness when we don't know if the person actually died? You have not established the ingredients of the offense. That's what I'm asking.
Okay. Thank you. Actually, the problem here is that the prisoners, I think the prison authorities have it wrong. If you read Rule 1, plea bargain may be initiated, by the accused or prosecution at any stage of the proceedings. So right from the time this a person is charged, even on day 1, that process. Yes, Justice Abodo, please.
Yes, my lord, you're absolutely right. Actually, we encourage the prosecutors and the police. That's why we need the police on board as well. That sometimes the person arrives in the day they are actually arrested. They accept and say, I know the offense, I committed it. It is actually possible to have this person committed and they do plea bargain on the same day. It is very possible, and we encourage the prosecutors to do that. That people who want to do plea bargain, it doesn't matter, they don't have to wait in the system. We can have them committed in the same day and they plea bargain, if it is a capital offense.
Yes, thank you.
Yes.
I hope the prison authorities have heard. As soon as somebody expresses interest, even if they have not been committed, just inform the, your list. Let that person go on that list. Yes, I'm seeing Justice Elubu.
I wanted to say the very same thing that the DPP has said. Actually, we had tried in the criminal division to have what we call a fast track, so that whenever there are inmates, when the cases are fresh, they are handled the perspective of the accused persons is very different from the time after they have spent some time in prison. So if you can put in place a fast track mechanism where the ones that indicate that they want to plea bargain, that is the best time to get them. You get them committed immediately, and then put on the lists, and then they will do the plea bargain.
Yes, my lord.
I'm also just adding on to that. I think I remember in 2017 at a judges conference, that time I was presenting a paper on behalf of the defense lawyers, and that was our issue, because we had clients who were not being committed, and they're waiting to be arraigned by police and embarrassment and all that. And that time Justice Chibita was the DPP. So I think the undertaking that time and the understanding was to start setting up a focal judge. And her lordship now, the DPP, was I think the first focal judge. The Justice Jane Kuo now is the focal judge. The understanding was if the defense or anybody else has got a person who wants to plead guilty, even as they are looking for them to be arrested, they then can go and the focal judge can arrange for that person to make sure that they are committed by the DPP and fast-tracked. So that mechanism was set up in 2017. Yeah.
Now, in this case, I think she was later on committed, but then she had to wait for 4 full years. Could it be a problem of communication between the women's prison and the men's prison? Who usually submits the list? That it's just the OC of the main prison. And I think our role as judges and probably even prosecutors is when you don't see a woman on that list, proactively ask the OCs, why don't we have any women on this list? It could be a communication problem because 4 years she wants to plead guilty and somehow she's not getting on that list. I hope the prisons will address it, and perhaps we could have some kind of understanding memorandum with the prisons because they don't feature here in the rules. How we can compel them, to do this. So let's, because of time, yes, Your Worship. Sorry, my Lord, we'll start to move to the next question.
I think when we heard from the PJ in the morning how they used to do it in Mbarara, I think even us as judicial officers, it is upon us. I think that scenario cannot happen in my case because I always go to the prisons. If such person is there, then they will tell me and I take it up. Because we go as a team, defense and then the ODPP. If that case is there, then it can be picked as early as possible, not wait for those 4 years.
Thank you. Let's close this. The final one, Justice Lubo.
Let me give the experience from the criminal division. We have what we call a prisons liaison officer who is stationed at the criminal division. Now, his work is to coordinate between the prison and the criminal division. So a scenario like that one is unlikely to happen in the criminal division, because this person actively engages with all the prison units, all the issues that inmates have, brings them directly to the court, and they are handled. So it would be good to have a mechanism. You can do it through the DCCs. You can do it through a focal person. In the circuits, it is normally one regional officer, one DPC for prisons. So you can actually have that person actively engaging with all his units to make sure that a scenario like that one doesn't arise.
Thank you. Those are best practices.
My
I'm
lord,
sure, yes.
Justice Kasure
Oh, Justice
wanted
yes,
to say
sorry.
something.
My lord.
I am a bit puzzled because doesn't the answer to number one depend on number two? Because would the prosecution or the one conducting a plea bargain proceed with the plea bargain involving happiness when actually the purpose of the plea bargain is not because she committed the offense? There is no straightforward evidence to that. The purpose appears to be to protect her sons. So just for the sake of ensuring that justice is quickened up, if one offers to plead and to undergo a plea bargain process for the purpose other than having you committed the offense, would the prosecutor or would the court proceed to conclude the plea bargain process?
Thank you, my lord. You have now taken us into the second question. I think let's tackle it, then we can perhaps also go back to the first question. Yes, I think they are related. Let's now discuss question number 2. Your Worship, Buchanan, please, the second question.
Question number 2. The prosecution concedes they have no evidence on the role of each of the accused in the murder, and that it is possible that the sons are the ones who actually killed the deceased and not Happiness. They also cannot rule out the possibility that Happiness is the one who delivered the fatal blow. The court is not satisfied that the evidence adduced implicates Happiness, but she insists she did it. There is no confession on the police file. Do you proceed with a plea bargain? Share views from the perspective of the defense, the prosecution, and the court.
Yes, you've heard that question. You know, now it's like she has now, somehow she has now got before the judge, and she wants to, she's now, you know, they're in that process negotiating. Let's share perspectives on this. Yeah. So do you proceed with a plea bargain if you are the court? That is the number one. That's the first question that was asked. She wants to, you know, she's saying she did not, did she say she's killing? Yeah, the state does not have, you know, direct evidence, but they know she participated. And they also not, they also think the sons. So how do we go about this? The role of, we can start from the prosecution. What is the perspective of the prosecution on this? How would you approach this scenario? The prosecutors, let's hear from the prosecutors. On question number 2.
Let me see the prosecutors. I think I'll just use circumstantial evidence. I would use circumstantial evidence because they say plea bargain, someone has to come in knowingly, as long as I'm satisfied as a prosecutor that happiness actually caused the death of the husband, because the other allegations of the sons helping, there's really not much evidence, but at least there's circumstantial evidence to show that happiness could have actually caused the death of the husband. And then I would actually engage in a plea bargain, and then I would be lenient, because from the facts, it says that he has been I think there has been domestic violence in their relationship, in the marriage. So I would be alive to that fact, and since Happiness wants to do a plea bargain, actually it would be better that she does a plea bargain in this, because then you also don't want to continue with the trauma and all that. So I would, as a prosecutor, I would comfortably do a plea bargain with Happiness.
Okay.
Thank you.
For murder, yes. It would be murder, my lord?
Yes, it will be murder.
Okay, it will be murder, yes. Yes, another perspective, I can see two hands there, yes.
My lord, I would like to agree with, to refer to Scott, Scott Late's, his presentation when he said that trials are unpredictable and there's no point going to trial if your evidence is uncertain and fragile and proof changes. So I think this is a good case for plea bargaining, because the evidence is, well, there is a body, there's blood and all that, but it wouldn't work on a trial. It wouldn't succeed as fast and as decisively as you would with plea bargaining.
Okay. Thank
so
you.
I would go with that.
Thank you so much. What about defense counsel? I'm sure we have a defense counsel in the room. What would be your perspective? Yes, there's a hand there.
I think that it would be best to reject the plea deal and go to trial, because there's a plethora of defenses that they could explore for Happiness and for the sons themselves. Firstly, the plea that they're asking her to take is for murder, but it's a possibility that could have been, in South Africa we call it culpable homicide. I think in Uganda it's manslaughter, if I'm not mistaken. And there's also the issue of domestic violence. It could have been self-defense, and the children could have also acted in private defense of their mother because there was an imminent threat. So I think this would be the type of case that has to go to trial and not take the plea deal to quickly settle the case, because at the end of the day we need effective justice and not just fast justice.
Okay. And thank you. Perspective of the judge? What would the judge do in these circumstances? You're participating in the negotiations. Would you agree?
No.
Yes.
Before we go to the judge, I think there could be two positions for the defense. Because one set of the accused, the sons did not acknowledge their guilt or involvement in the killing of their father. But the mother accepts the responsibility. Whether she accepts because she struck the fatal blow or she's protecting the children, I think her interest in plea bargaining should be entertained. Because in any case, even if it was the children for which there was no evidence, she thinks that they were protecting her. Therefore, she ultimately holds the responsibility for the husband's death. So we should, I think, allow the two scenarios to go concurrently. Maybe in respect of the sons, they could go for trial, and in respect of their mother, they could entertain plea bargaining.
Yes, thank you, Honorable, for that contribution. We shall actually address that in the next question. You know, the sons, what happens to them in situations where we have multiple accused persons. So we shall address the issue of the sons in the next question.
My lord, I wanted
Yes.
to say something.
Yes.
I'm behind you. May
Oh,
not
yes,
see
please,
me.
go ahead.
My lord, I think the principles of common intention would sort out question 2. Our dilemma is on the role that each played.
Okay.
So it doesn't matter who hit the final blow, as long as each beat. That is my submission. So we can go for plea bargain because each of them did something.
Thank you so much. Yes, and all this takes place within the parameters of Rule 6 of the plea bargain rules. Let's not forget all that we are saying is grounded in the rules. Now the judge, what about the judge? Would you agree? You as a judge, what will you be thinking about this case? Does this woman have any defenses? As a judge, any defense? Does she have any defense in the event it's murder? Or it's just mitigating factors, domestic violence. But it could also be self-defense, Somebody is holding a panga, they're hitting you, he's drunk. So, as a judge, I think you have that in mind when the sentence is negotiated, when the parties come before you, when the defense counsel and prosecutor come before you to confirm the sentence. You have that in the back of your mind. So can we move now to the next question?
Question
yes, and we said reducing the charge to manslaughter. That one is also provided for in that. All that Rule 6 provides, mandates all that. So now let's go to number 3. Your worship again.
Happiness informs the prosecution through her lawyers during negotiations that she committed the murder single-handedly and her sons are innocent of the crime. What happens to the co-accused?
Yes, that takes us to Honorable Baku's concerns. What happens to the co-accused? For them, the mother says they're actually innocent. She's the one who did it. So what happens from that moment onwards? Do you send back these people to remand? Because I'm sure they are denying. They don't want to, Yes, let me have Betty first. DPP.
Thank you, my lord. In this scenario, I would assume that it is Happiness who signed up for plea bargain. So it would be Happiness who is actually appearing before the judicial officer. And according to Rule 6(2), we would proceed with Happiness's case, and then we consider the sons for trial as a separate trial from the mother. And really what the mother says before the court doing plea bargain would not affect the case of the sons, because that would be a separate file. So she cannot stop the process against the sons. Yes. Because here when you look at page 1, the last paragraph on page 1, the sons actually admit that they came in to support the mother as her husband was assaulting her. So as a former prosecutor, I think I would really proceed and have the trial for the sons. That is
okay. They are the only witnesses, remember? Okay. So yes, my lord Kauka.
Evidence. Thank you so much, my lord. If I was a judge where the Happiness is insisting that she did it alone and her sons are innocent, I would be reluctant to take her plea bargain, because in my view it would negatively affect the trial of the sons. So I would actually reject the plea bargain and go for a trial. That's how I would deal with it. Because we have had a situation where we had at the anti-corruption, there was a bribery case involving 2 people, one prominent person and another person who is not as prominent. Then the one who was not prominent kept on saying, "It is me who did it and I did it alone." the other one was not party. And so you could see that actually the intention is to exonerate that very prominent person. So we say, no, we are going for a full trial, we shall adduce the evidence, and whoever is found culpable, we shall take that one. So if I was a judge, and actually if I was a prosecutor, I would be reluctant taking that plea bargain. Thank you.
Okay.
Question, my lord.
Yes, my lord.
Would the provisions of Rule 6, Sub-Rule 2 be helpful in that event? That actually, where there is more than one person, a plea bargain may be entered in respect of any of the accused persons, and the subsequent plea agreement shall apply and be binding only on the accused person who entered into the agreement.
So,
Would
my
that
lord-
be helpful?
Thank you, my lord. I think, my lord Kawuka, you can see the rules allow for that, having separate, can have plea bargain for one and the others can deny the offense. It's their right. It's not the same judge who's going to handle the case, though. It will be another judge who will handle the trial, I think. Yes?
Can I?
Oh.
I think if I were a judge, I would take it on. And the experience is that, and I've seen it many times, in matters of many accused persons, the moment happiness gets plea bargain, it is more likely, the percentage is higher, almost 80%, that the sons will follow and do plea bargain.
Okay. So any other thoughts on this? An experience, anybody who has experienced this? Yes, yes, my lord, Kawa.
Mine is about, first, I want to thank DCJ because I think that is...
We're not hearing the microphone, please. We're not hearing.
DCJ has told us the correct position of the law. And for this lady, if it is manslaughter, she's going to take it. But the provisions of the law in section 19 to 21 of the Penal Code Act have participation of more than one person. So there is aiding and abetting, common intention, accomplices, and that kind of thing. Now, those boys don't have to agree to anything, but if they are charged as accomplices, then the judge could, as a mediator, also point them to the fact that they could enter a lesser charge as either accomplices or that kind of thing. Then you would have it completed at plea bargain. If not, then you would have to go for full trial for the rest of the people who have not entered the plea bargain. But the mother admitting that she did it alone does not take away that intention, because the interpretation of the law is that you could even observe and not do anything, therefore you are omitting to do something, you would be culpable. So it is very wide for accomplices and people who are aiding and abetting and those with common intention.
Thank you for your thoughts. Any other? Yes, the last one on this. Yes, please, go ahead.
Thank you so much, my lord. For me, I will look at criminal law is about personal responsibility. If happiness is willing to enter into a plea bargain, I would encourage her to go on and bargain on her part in this criminal nature, that she admits liability of committing this offense. And then those ones who are still denying, it's their right. They are innocent until proven guilty. So happiness will be rightly into the line of plea bargain in this
Okay,
matter.
thank you. I suppose the DPP here would play a very big role. They could probably go back to their file and see if they can prefer other, lesser charges, like accessory after the fact. And if they cannot, then me as a judge, I would fix the case for hearing so that, the state can produce their witnesses. And if they don't, then, I give the necessary orders So it's really the ball is in the DPP's court because they've said, yeah, there's no evidence against them. I wouldn't, want those boys to stay another how many years, waiting for a session. I've done this, proactively fix the case, and the state has to proceed if they cannot enter nole. Yeah. So let's move now to the next question. Yeah, the last one is if there was, how many questions? Right, thank you. If there was evidence that it was Happiness who killed the deceased and the parties were considering manslaughter, would you as a judge allow this? Yes? I suppose this is straightforward. If, yeah, there's evidence she killed, would you as a judge allow manslaughter? And I think we have had discussions around that this, because of the domestic violence, self-defense, etc. Would allow manslaughter. Yeah. That's the consensus in the room. Yes. Once they have presented that if the state they've agreed that this woman is charged with manslaughter, that's it. There's no need for the judge to try to interfere and bring the charge higher, elevate it to murder. Also considering the family context and all this. And no one is willing to testify, so, yeah. So thank you. That is the end of my role here.
Okay.
Thank you so much for that presentation, which was participatory.
Well, if you have no evidence against the other two, the sons.
Before I hand over to the Deputy Chief Justice to continue with his session, there are some unfinished items on his session, so he's going to continue. I'm going to call upon Professor DeWalt to come and perform some important function, which I think you are already briefed about. Thank you so much.
Thank you, my Lord PJ. As we've seen throughout the day, it's a special day, it's a monumental day, and we wanted to return for just a moment to celebrate our pioneers by having an opportunity to award them with their certificate of being a pioneer in this pilot program, have their picture taken with DCJ and PJ to commemorate the incredible work that they have done. And so I want to return to the districts where the pilot programs were run and invite each group to come up and have their picture taken and receive. We'll offer one certificate to the leader, and then at the end of the day, each person will get their certificate in the interest of time. So in the first place, I would like to invite from Nakawa, the Honorable Justice Lawrence Gadudu to come up with your team, Honorable Lady Justice Alice Hauha, Ms. Samali Wakuli, Ms. Jackie Namazi, and Ms. Susan Sylvia Wakabala, if you are here. Justice Gadudu, if you would come forward with your team. My Lord DCJ and PJ. our next group from Mubende. Please join me in honoring Honorable Justice Lamek Mukasa, Mr. Brian Kalanaki, Miss Esther Nakamate. If any of you are here, please join us up front. No one's still present. Perhaps we can honor them with a hand clap. From MPG, please join me in thanking Honorable Justice Henry Peter Adonio, along with his team, Ms. Caroline Nabasa, Ms. Catherine Namakoye, Ms. Sylvia Namaweje, and Mr. Kafuko Ntuyo. I believe we have a defense lawyer from Chiboga in the pioneer days who is now a High Court Justice. Please join me in thanking Honorable Justice Alan Nchimye. And then from our list of pioneer OCs, we have two with us today. Please join me in thanking Mr. Wilson Magom from Upper Prison Luzira. Thank you very much. And please join me also in thanking Mr. Moses Santalo from Chigo Prison. Maybe he's no longer present with us today. Thank you so much for taking time to honor the pioneers. One final round of applause for our pioneers. Thank you, DCJ and PJ. Thank you.
Okay, thank you so much for listening to me as the chair of the session. And I take this opportunity to thank the presenters. These were wonderful presentations, and I'm sure you have benefited a lot. We are going to have a short break of 25 minutes as we prepare for the keynote address on cross-cultural perspectives and dimensions to negotiations by Professor Singh. His second name is, let me not, is that one. So I think Honorable Justice Taylor will chair that session. Oh, Sorry, I think someone is suggesting some plenary of sorts. Yes, my lord. Yeah.
I just wanted to thank Judge Williams here for the point he made about the checklist when you are handling a matter of this nature. The truth is that failure to involve victims in the negotiations is discrediting plea bargaining. It is discrediting plea bargaining. Some communities, we've been told, because we've just returned from a training up country, some communities are beginning to see ex-convicts returning home. They didn't participate in the trial. They think these fellows are escaping, and they lynch them because they were not aware that trials took place in the first instance. And actually, some people have suggested that if there is room to amend the rules, you put a slot for the signature of the victim or representative, so that in case the DPP decides to proceed without victim participation, at least there is reason on record as to why the victim was not consulted or does not appear in the matter. That's for the future if we are to amend the rules. But the truth is that victims are being left out, and this is discrediting the plea bargaining process which we started long ago.
Okay. Thank you so much, my lord, for that wonderful contribution. I think it's food for thought, and as the Law Reform Committee, we shall perhaps look at that and see the way forward. Thank you so much. Okay, so let's have a break. We should be here by 4, because at 4 prompt we shall begin the next session. Thank you. And kindly remember that you have certificates at the end of the session. Don't leave them behind.
I have not worked, but we can get. Let them do that.
Lord, let's settle in. We have a minute to 4. IT, please. We are just about 4 p.m. Let's settle in and we move to the next keynote speech.
My lords, yeah, that I think wakes us up. Professor Singh should be online now. They tell us he's ready, so if we can begin.
Wonderful. Yes, ma'am. You can hear me, I think.
Host has switched off the video. The host has switched off the video.
Yes.
Okay, let me check.
Yes, Professor Singh, are you?
Yes, I'm here, Your Lordship. Can you hear me? Can you hear me, Your
We
Lordship?
can see you. Can we now talk to you?
You can see me too? Okay. I just want to make sure my Lordship can hear me and see me.
Hello? I think you are muted.
I'm going to re-sign. Yes, brother.
IT, do we have a problem? Do you?
Thank you.
Yes.
Just wanted to be sure I can be heard.
Yeah, let me take opportunity to introduce Professor Singh. He is the director of the Strass Institute, Caruso School of Law. But more to that is that he's one of the friends of Uganda. He's been to Uganda. He has been, first time to know him, he was our lecturer for the masters, for the class that did a masters in alternative dispute resolution and arbitration. He's a very experienced person on the topic on which he is going to address us, that is on cross-cultural perspectives and dimensions to negotiations. He has practiced what he's going to talk to. From what I know, is that he has practically practiced this in Afghanistan, in India, in China, in Brazil, and many other countries. He's a practitioner and a lecturer. We shall benefit a lot from Professor Singh. I'll not go into his qualifications because that shall take our time. And if I started, we would begin the presentation at midnight. So to cut the story short, Professor Singh, you are welcome to talk to us.
Your Honor, the Deputy Chief Justice, thank you for the honor. I just want to make sure you can all hear me. If I pause and see.
We can.
Thank you. Your Lordships, the Honorable Chief Justice, the Honorable Deputy Chief Justice, other Chief Justices, judges, honorable guests, the Vice President of Pepperdine University, my dear brother, Professor Hava. It has been an honor to be with you this morning, early morning for me, and evening for you. I will do my best for a few minutes to speak to you about the topic that's very close to my heart and close to my mind, the topic of cross-cultural respect in communication to be able to bargain with you. There's a famous example of an Indian ambassador in London. She was negotiating on behalf of India Comprehensive Test Ban TT, CTBT. This is a test ban on nuclear weapons. It's an important negotiation. And a British diplomat made a joke about Indian civilization. This woman, Miss Ghosh, gets up from the table and leaves the table. No negotiation. When you disrespect someone in some cultures as part of communication, negotiation is over. So coming back to the heart of negotiation, I mentioned your looks, I mentioned your thinking, I mentioned your behavior, your communication. Beyond that, culture is powerful because it controls your decision making, how we decide. Now, friends, decision making is very important. Decision making is critical. Decision making is especially important across cultures. But why so? Why do we have to think about decision making? And I'm going to give you 3-4 tips on decision making, and I'll be done on this topic and move towards conclusion. 4 points on decision making. Number 1, decision making is emotional. Across cultures, we demonstrate, explain emotions differently. If you watch a movie from America, there is more brain. It has to do more logic. I'm not talking about any given movie out of 100 movies. You pick up a movie from India, there's higher chance there's going to be more emotions, more crying involved. People are more vulnerable to emotions. They have a different relationship with emotions across the world. Then decision making is cultural. Based on where I grew up, I can decide differently. In some cultures, we decide with the village. Collectivist decision making, asking the entire family. Where I grew up, I'll always ask my father, before I buy a house, before I buy a car, Father, is that a good investment? Should I do this? Where I'm living right now, sometimes you make your own decisions because it is about your power to be independent, to be self-serving, that you can decide independently. Point number 3 in decision making. Decision making is influenced by time. Time is very unique across cultures. Today I'm surprised that I was called to speak earlier than usual. Usually I have to wait a few minutes when I'm speaking in Uganda, when I'm speaking in Brasilia, in Brazil, when I'm speaking in Kenya, when I'm speaking in Rome, Italy, when I'm speaking in New Delhi. I have to wait for a little bit because time is seen differently. Versus when I'm speaking in Japan, when I'm speaking in Korea, when I'm speaking in New York or California, and especially when I'm speaking in Germany, time is seen differently. It is more strict. It is more punctuality. So today you have proved Brazilians, you have proved Germans, Americans wrong by finishing your talks earlier. And I'm very proud of that. And I'm very pleased to see that. So time influences decision making. Why? Because, my friends, time has an inbuilt healing power. In some cultures, we resolve conflict with time. We don't discuss conflict. We don't resolve everything directly. We resolve it indirectly. Which brings me to my last point on decision making. Decision making is also about personality, people's past, history. Understand where people are coming from. And culture is all about history, isn't it? Some cultures are past oriented. We are proud of our roots, our values, our faiths. Some cultures are future oriented. We are proud of our computers. We're proud of our cell phones. Look at the importance. One is looking backwards and one is looking forwards. Now, do not think backwards looking is a bad thing. Sometimes the wisdom is in the past. It teaches us things which can help us to change the future of the mankind while understanding the past. So, let me conclude my small discussion today with you all. If we apply this to the heart of mediation, heart of negotiation, how does that work? I said culture is powerful. Culture is important because all of us have it. Culture is also complex. Complex because we have subcultures. We have age, we have gender, we have faith, we have region, we have education, we have money, class. All of them play a role in us being a cultural person. So where is the heart in this? Now, colleagues, heart is in how you represent your culture. Two people from the same culture cannot represent the culture the same way. Now, if two people cannot represent the culture same way, then how can a million, a billion people represent it the same way? And if that's not a possibility, then how can you say all Indians are like this? Or all Ugandans are like this? So culture solicits, invites this idea of stereotypes, generalization. And many times we are not just wrong, they are incomplete. They share one story of who we are, not multiple stories. I am a writer. I like to speak. I'm a speaker. I like to pray every day. I'm a man of faith. I have 2 children. I'm a father. I have a wife. I'm a husband. I'm a professor, so I'm a teacher. I like to mediate, so I'm a mediator. I have a law degree and a license. I'm a lawyer. Which one are you listening to? I have so many identities. And then I'm a very proud American and a very proud Indian. So if you combine them all, each one of us have these multiple identities. The question is which one is playing a role at a given time? And that's where your heart comes in. I'm going to leave you to thinking that we should practice. We should do more dispute resolution through heart. And here's the reason why. Because heart has no limitation. Mind has limitation. Heart has passion. Mind has energy. Heart gives without thinking what to get in return. Mind believes in reciprocity. Heart is limitless. Mind has limits. Heart is generous. Mind is shrewd. If I listen to both of them, perhaps I can be a good negotiator because I need both. I need generosity, but I also need street smartness to be able to be a good negotiator. So if I make you think about this, a good negotiator, especially across cultures, is not just there to listen, be kind, be humble, be flexible, be open to modification. A good cross-cultural negotiator is also who can present their culture, represent their belief system, have a backbone, have a value system, and defend it when needed. So you need, if I may borrow from my faith Sikhism, you need to be a saint and you need to be a soldier. You need to have a heart of a saint, content, peaceful, ever-giving, courageous, and a mind of a soldier, willing to fight when needed. I hope these 25 minutes were helpful to you. There's a lot more in cross-cultural thinking. So I will end you with these final 1-2 thoughts and let you enjoy your evening with your loved ones, with the terrific judiciary that you're with. I will end by saying that we are part of a system today. And my learnings are, our stress and our conflict is within a system, not outside the system. Think about age, what age we are in. I'm not asking our age individually, but collective age. We're in 21st century. We are in a post-market revolution, industrial revolution area. We're at a time when artificial intelligence is taking over, when we're discussing climate change and we're discussing international travel has become so easy. Imagine the difficulties that 16th century or 15th century people faced. Was that different? Absolutely, that's going to be different. Or 12th century, or 10th century. So if you combine as a human race, what have we learned? How far have we gone? So it's not just your culture as Ugandans and my culture as American or Indian American. It is also about our culture as a human race. Where are we headed? So culture makes you connect with each other from a very large, beautiful fabric that is unseen, but that is felt. And we're all part of the same fabric. So end of the day, it's been an honor to speak to you, to be with you, because your fabric is the same as my fabric. All I have to do is realize it. Open my eyes, open my mind, and open my heart, and I can see it. It has been a wonderful pleasure to speak to you today. I had a chance to visit Kampala, Uganda, earlier this year, and I've become a big fan. I've promised some of my dear friends there, the Honorable Chief Justice, the Deputy Chief Justice, Professor Hauha, and others. I've promised that I'll come back, and the next time I come back, I'll bring my family, because I want my children to live, not to visit, but to live there at least for a month, or maybe 6 months. Why? Because you know how to pause. You know how to use silence. You know how to bring presence to any conversation. You folks have joy in you that some of us in America are searching in books, in travels. You have it in your heart, in your soul. It cannot be stolen, so don't worry. It can only be shared. So thank you for sharing that joy with me. Thank you for this invite. I also want to thank our Vice President, Danny DeWalsh, for the kind invitation. I do have to leave today to give another lecture in downtown Los Angeles traffic, which is not good in the morning. So I have to seek your permission, your blessings, and I thank you for your time.
Thank you, Professor Singh. Thank you very much. Permission to join the traffic jam is granted.
Thank you. Thank you, Deputy Chief Justice.
We now move to pre-bargain conference certificate awards ceremony. We'll call President Jim Gash come forward, and I've been authorized by the Chief Justice to join you for this ceremony. Thank you.
All right. Check, check, check. All right. Thank you so much for a fabulous day. Thank you for being here. We want to celebrate you by awarding you with your certificate of completion of the 7th Annual National Plea Bargaining Conference. And we want to begin with the Honorable Deputy Chief Justice Richard Butera. In the interest of time, I'm going to move through these briskly, and so as your name is called, you can sprint to the front if you'd like. Next is Honorable the Principal Judge, Dr. Flavian Zeja. There you go. Honorable Lady Justice Jane Akuo Kajuga. The Honorable Justice Michael Elubu. The Honorable Lady Justice Florence Nakachwadolo. The Honorable Lady Justice Comfort Kania. The Honorable Justice Allen Nshimye. The Honorable Lady Justice Joyce Kavuma. Honorable Justice Godfrey Namundi. Honorable Justice Henry Peter Adonio. Honorable Lady Justice Ketra Katunguka. Honorable Lady Justice Alice Kamuhangi Hauha. Honorable Lady Justice Patience Rubagumya. Honorable Lady Justice Jacqueline Wanda. Honorable Lady Justice Cornelia Sabiti. Honorable Justice Eva Luswata. Honorable Justice Vincent Mugabo. Honorable Justice Lawrence Gidudu. Honorable Justice Paul Gadenia. Honorable Justice Douglas Singiza. Honorable Justice Isaac Muata. Honorable Justice Lamek Mukasa. Honorable Lady Justice Patricia Basaza Waswa. Retired, the Honorable Principal Judge, Justice Yorokam Bamwine. Retired, Honorable Justice Remy Kasule. Retired, Honorable Justice Augustin Nishimye. Retired, Honorable Justice Albert Rugaja Tuki. Retired, Honorable Justice Paul Mugamba. Maureen Kasande. Retired Honorable Justice Vincent Zehurikize. Retired Honorable Justice Frederick Ruhindi. Honorable Lady Justice Sting Kahawa. The Honorable DPP Lady Justice Jane Frances Abodo. Honorable Justice Lawrence Tweyanze. Honorable Lady Justice Henrietta Walayo. Miss Margaret Nakagude. Amatu Haire Alexandra, State Attorney. Forgive me for this one. Sharon Akwadwanirira, State Attorney. My apologies. Jennifer Amumpere. Mr. Amo Singalobe. Miss Betty Kisa. Maxime Elizuba T., Chief State Attorney. Miss Susan Sylvia Wakabala. Faith Niwagaba, State Attorney. Moses Onenchan. Jane Frances Attai, State Attorney. Ms. Samali Wakuli. Odongo Mahatma Willie. Ms. Cheryl Tabaro. Abire Judith. Atukunda Rita Katurebe. Mr. Uvan Kiaze. Her Worship Akello from Nikawa. Her Worship Nyamwenge from Nikawa. His Worship Otim Makono. His Worship Gukina Nakifuma. Her Worship Lamunu Makono. Kabeba Derek. Rona Ankunda. Baku Raphael Abudra. Namudu Mary. Magara Rorley. Tumohire Barbara. Emmanuel Aremba. His Worship Salam Godfrey. Ntalo Nasulu Hufeu. Daniel Bonbale. Tingu Beatrice Stella. Lumunye Timothy. Hassan Kato. Olive Mutonyi. Mr. Jacob Kige. Claire Natulinda. Aaron Nagawa. Habiba Nalumo. His Worship Namanya Frank. Ms. Jackie Namazi. Mr. Turiyakira Anaklet. Mujwezi Anthony. Mrs. Robina Shanubi. Turia Musima Jeffrey. Abuelo Sarah. Mututa Martin. Selwabala Julius. Mr. Arnold Joel Ayiko. Julius Mwesije. Musaya Alice. Kongyai Caroline. Privilege Sumberani. His Worship James Eremier. Mr. Magomu Wilson. Moses Otim. Mokoya Maureen. Nabwire Juliet. Her Worship Juliet Hatanga. His Worship Kidasa from Nikawa. That's her. Apologies, Her Worship. Her Worship Nambozo from Kayunga. Namudu Mary. Mujwezi Anthony. Thank you so very much. In light of the time, if you were unable to come forward for your certificate, we do have it here, and we invite you at the conclusion to come and receive yours here. And with that, my Lord DCJ, I turn it back to you to close our time.
My Lord, the principal judge, my lords, all of us friends, let's really congratulate ourselves for this day. I want to start by thanking all the participants, for it is rare that we start a conference on time at 9. We are still here and it's a full house. So thank you very much. This is pleasant to see. Let me also start by thanking Pepperdine University, Professor Gash, Professor Dewalt, and the whole team, including the students working with us at the back. I would, in that group, include Professor Uka, who probably does not want to be recognized, but we know is working hard with us all the time. Thank you very, very much. I think all the organizers for this conference deserve appreciation. Let's give them. I think the group that we can't forget are our presenters, the ones who led the discussions today. I think we had a new work method where we were all kept active, involved, and that's why the conference has been so rewarding. We are now on alternative dispute resolution mechanisms that we are introducing not only in the pre-bargain, but also in other aspects of our dispute resolution mechanisms. Last week, we commenced mediation in different courts by our mediators, again, thanks to Pepperdine University for the training and involvement in all this. It is very useful. As we said, the mediations we are starting are a pilot, but a useful one. Most of the people involved I can see are here. Please, let's see how it works. Let's note what is working, what is not working, how best can we improve what we have started. With the passion and the involvement of everybody, I am confident we shall succeed. So this conference is an addition to other training programs that we shall have together. This is the 7th conference, but actually it should be the 11th. There was a COVID time that denied us other conferences. So probably we are on catch up. We shall catch up. But with more training, because after we have trained, other people come up and they are new and they have not had the training. After the training, there is a lapse and the people forget what they did last time, but we shall continue the trainings. So let's have the spirit, the will, the involvement we saw today. It is very encouraging. Let me say we closed the workshop today, but we have not closed ADR. Let's go to work. Thank you very much. The conference is closed.
Thank you very much. My lords, distinguished guests, your worships, we have a cup of tea. Let us partake of it so that we don't render that expenditure negatory. You are all invited to the cup of tea. The lords at the 7th floor and the other guests at the 6th floor. It's not intended to separate you, but it is just space. Thank you very much, and I beg to close. The drivers of the following vehicles, you are requested to move and adjust them. There is a